Yes. What is this? Acha. So to be mentioned? To be mentioned. Tomorrow. Yes. Right.
In this matter, there is a dispute with the fanatics.
Similar as the previous one?
It's not similar.
Acha.
So in this case,
Yes.
actually this second round, first round it was remanded back, and now it has come for the second time. So this is in the bottom of the list. I just want to request that it may be taken up for the interim relief part.
Very well. Then
Because none of the private respondents or the petitioner were promoted till date based on the influence seniority list.
Acha, this will appear under the heading application tomorrow. Tomorrow, the application and contempt applications will be put first. Tomorrow we'll take up the application and contempt applications first.
No, this is the.
So there is a connected. You said intending order.
58. Item number 58 WPC.
It's appearing with an application.
Oh, it is appearing with as for hearing.
No, for hearing you understand. Oh, then
Okay.
hearing is difficult. Then application gives preference to applications tomorrow. That's different.
Right.
Then we can it as very little. It will appear at the top after the top matter, other top matters tomorrow.
Because I just want, if there is quality of time, then we can only I can pay for the interim relief. I want to stay of the interim seniority list till the final year.
Well, it will appear at the top after the other matters which have been fixed at the top.
Yes.
Right. Yes, Mr. Hassan.
Whose was granted against that the husband's filed the
Ask. This is an appeal hearing.
hearing.
Will you be able
Yes,
to?
you are filed. There is a direction upon the petitioner appellant to pay the maintenance amount already granted by the family.
Not paying.
Paid will at some part is left over. So compliance is to be there.
So we'll put it as to be mentioned, and then you give a notice to the other side.
I'll be.
It will appear as to be mentioned tomorrow, so that for that part we can decide. Cover. 49. All the list. And the factor.
Still. Yesterday.
Oh, we have mistakenly directed it to be released from the list. By your order dated April 20, 2026, due to an oversight, we had directed the matter to be released from our list and the file to be sent to the learned district judge, Andaman and Nicobar Islands. However, since it is the district court which has pecuniary jurisdiction to hear the matter, FAT 2 of 2025 and FAT 3 of 2025 are dismissed as not maintainable on the ground of lack of pecuniary jurisdiction, with liberty to the appellant in each of the matters to prefer appeals before the concerned district court on the self-same grounds as taken in the present appeals. First up, next para. It is expected that the time spent during pendency of the appeals before this court shall be considered under Section 14 of the Limitation Act while entertaining the appeals, as and when filed before the district court. First up, the learned advocate on record for the appellant in each of the matters is granted leave to take back the certified copies of the impugned judgments and decrees upon furnishing photocopies thereof for the records. for the purpose of preferring an appeal before the jurisdictional court, full stop, no address to costs.
Substitution application is also.
The application should automatically go.
Cannot file appeal against a request. That's difficult.
So that will go along with the. If they prefer an appeal there, they have to file that there also.
No, I have to file the appeal.
You are the appellant.
That person.
Yes.
Then with substitution.
Yes, just like you did here. It was up. Interim order cannot be extended. We have held interim orders, if any, stand vacated. With liberty to pray, with liberty to make, with liberty to make similar prayer before the concerned district. Mr. Prasad, is stay maintainable against deceased person? We are not going into that. Next.
Nothing is against a dead person.
Next. Yes, Mr. Jain.
Same has to follow even in this
Just sit.
same 3, 4, and 5. Same.
In view of a larger bench decision of this court, comma, it is the district court which has pecuniary jurisdiction to entertain all first appeals in the Andaman and Nicobar Islands. Accordingly, FAT differently in each of them, 6, 8, and 9 of 2025, comma, along with the connected application only in 4 and 5.
That's right.
Other connected application, however, is dismissed due to lack of pecuniary jurisdiction, with liberty to the appellant to prefer an appeal before the concerned district court on the self-same grounds as taken in the present appeal. Interim orders, if any, stand vacated. The learned advocate on record for the appellant will be at liberty to take back the certified copies of the impugned judgments and decrees upon furnishing photocopies thereof to enable the appellant to prefer the appeal before the jurisdictional court.
That's only one done.
No rest to cost.
Only one done. Instead of dismissal, can it be substituted with disposal?
We cannot do that. We have
rest would remain.
no. We cannot do that. It's not a dispute. It has to be dismissed because we don't have jurisdiction. Otherwise, we thought of that, but cannot.
Similar.
Using enough disposal. Because the merit is larger bench का हमारा राजस्व में देखता है सही से बुकिंग होना है इसी के लिए छोड़िए ऐसे से larger bench hey, this is put in. You can have only roots. Mr. Prasad, 6 is the Mr. Proval Mukherjee. That might. Yes, Mr. Kumar, have you taken instruction? File. File ta debe to baba. Yes, why not?
But please,
Can you please use the mic? Yes.
How the what is in favor of we can do some control workshops. Now not if lordships take us to secure the award. Still to stay of the award.
No, if you prefer an appeal, you'll do that. You have not yet preferred an appeal. There is no scope of that.
I understand because we went.
No, we'll do something.
Yes.
We'll say that because in any event, even if you had preferred an appeal, you would have to secure the amount. That will be our logic, one of our logics. But we'll also say that this deposit, if you prefer an appeal, this deposit may be considered to be a deposit, a statutory deposit in respect of that. So that will that if they file, then will lie. The limited prayer of the appellant stroke land loser is for a direction on the respondent authorities to deposit the awarded amount during pendency of the appeal. Full stop. The appellant stroke land user sought for enhancement upon which a judgment was passed by the reference court, comma, being agreed by which the present appeal has been preferred. Full stop. Next para. In any event, comma, even if the respondent authorities had intended to prefer an appeal, comma, which, comma, we are apprised, comma, they intend to, comma, the respondents would have to secure the amount as the awarded amount. Full stop. Accordingly, comma, we direct the respondent authorities to deposit the awarded amount with the registrar of the circuit bench at Port Blair, comma, High Court at Calcutta. Full stop. Comma, within 4 weeks. 2 months is too much.
That means 6 weeks from ago, we have to take.
That's very within 6 months from date.
6 weeks.
6 weeks. 6 weeks from date. Full stop. Next para. Upon such deposit being made, comma, the registrar shall invest the said amount in a short-term interest-bearing account stroke policy with any nationalized bank, comma, subject to the outcome of the appeal. Full stop. Such deposit shall be without prejudice to the rights and contentions of the parties in the appeal. So next para. Since learned counsel for the respondents submits that the respondents also want to prefer an appeal against the self-sent judgment, comma, we make it clear that the deposit as directed above shall be considered to be the statutory deposit in respect of such proposed appeal of the respondents as well. Full stop. Paper book directions have been given? No. Well, the appellant shall put. Pardon? It's already there.
Yes.
The appellant shall deposit the necessary requisites and costs for the preparation of paper books. Full stop. The paper book shall be prepared expeditiously, comma, preferably within 8 weeks from date by the department. Full stop. In view of the appearance of the respondents, you are for all the respondents, both. In view of the appearance of the respondents through counsel, comma, service of notice of the appeal on the respondents is dispensed with, and the appeal be treated to be ready as regards service. Full stop. Since we are informed that the trial court records have already arrived before this court, comma, liberty is given to the parties to mention the appeal for hearing as and when the same is ready for hearing.
There's a 8 weeks, 96 weeks.
6. 8 hours.
More submission there. Amount may be mentioned, otherwise they may deposit. Let's say already.
We are not going into that calculation. Whatever is there.
Otherwise they will deposit as per their choice.
You will have another opportunity to meet the judges. Next. Liberty mention job hearing. তাতে কি আপনার লিখতে হবে কি লিখবে থ্যাংক This is that matter where Mr. Sanjay was appearing.
Yes.
No, the administration said that they would say something, you would add something. Let them complete, then you can give a complete reply. So tomorrow, if he is not there today, even then I'm sorry, we cannot give you further time. You have to argue. If you start hearing Mr. Kumar in rejoinder, then we won't give you further opportunity. No question of person. Mr. Nataraj knows that we'll be taking up the matter. We gave it priority. If he has some other business, let him be engaged in that business, Mr. Kumar. We are not interested in his businesses. But sorry, no further time. Either you argue the matter or you hear Mr. Kumar and close it. In circuit, we cannot afford to give you further time. Because if we pick up a hearing matter, then we cannot come back to this matter. You know that. You make your arguments, whatever is there. If he's not there, what can be done? It's his choice. You cannot play with the court. Sir. You cannot play with the court. This is unacceptable. Yesterday he was there. He knew it will be taken up today. He gave it priority. Where will be closing your arguments you are going on to this? If you keep mum, Mr. Kumar, we'll take it that you don't have anything. Yes, Mr. Vinu.
On the other day, I have shown my lords the scheme promulgated by the administration as per the advice of the highest law officer of the country. And my lord will find that every aspect which has been carved out, more practically the three aspect, cut-off date, minimum qualification and sanction force that has been dealt with in the said scheme. Now, my lord, so far as facts are concerned, I will show only the relevant document and relevant paragraphs, my lord. My lord may kindly come to page number 90, my lord.
We are following the paper book.
My lord.
Page 90 is a judgment.
My lord, it's an order. This is
the order, yes.
The where an order was passed in the contempt.
In the contempt. Yes.
Now, my lord may kindly come to page 93.
93, yes.
Yes. My lord, after those directions were issued by the contempt court, my lord, in para 14, the court has recorded, let a copy of the which sent to the Ministry of Personnel and Personal Secretary to the Government of India immediately. So, at least on 3rd of August 2023, they know that there was this direction of scheme and all, my lord. Thereafter also, they did not initiate any process whereby asked the administration how you can finish. It was nothing there. I just want to bring this because it was within their knowledge, my lord, on 3rd August. So the court has communicated the order. Now, my lord, we kindly come to the affidavit filed by them before the Supreme Court, by the administration. It starts from page number 100.
Yes.
Paragraph, page 104.
This is the affidavit of the administration.
Yes. No, my lord, in the scheme also I have shown, my lord, that all the modalities were adopted by the administration, and even in the affidavit they have said so from page 104. It is not a simpliciter that they have framed a scheme without adhering to any law or the rules governing the service of payment. Page 104.
Yes.
Now, para 11, my lord.
Mm-hmm.
It is submitted that the administration in the process of formulating a scheme for regularization of DRM in accordance with the DOPT-OM dated 7th October 2020 regarding regularization such as required to be complied with the distinction stipulation laid down by the Supreme Court. That it is stated that underlying principles adopted in DOPT-OM dated so and so are threefold. Now, my lord, those principles were taken into account. The principles are there must be a cut-off date,
yes.
There must be a sanction force, and minimum requisite qualification. So this aspect was considered by the administration, and thereafter the administration in para 13 says, if the cutoff date is fixed on 10th April 2006, only 10 persons will be given regularization. So very purpose will be defeated, my lord. Now, therefore, in para 40, it is thus submitted that the adoption of so and so total and more even cutoff date needs to be adopted. An exercise carried out by the administration. So, my lord, an exercise was carried out by the administration has revealed that 4,400 DRMs have already completed at least 10 years of continuous service as on 1st August 2023. And if the set cutoff date is the next page says at least 59% of the DRM can be found eligible. And thereafter, my lord, it stated that second criteria, the Honorable High Court removed the distinction between DRM against sanction and so and so. Third, para 17 says third criteria regarding fulfillment of so and so prescribed in the recruitment would prevalent at the time of initial appointment. It is stated that the remaining DRM who did not regularize under this proposal would be given the benefit of age relaxation up to the number of service served in any future recruitment exam of the administration. That if the total number of DRMs were being regularized under this scheme is more than the available vacant post, then equal number of supplementary posts would be created to accommodate all the regularized DRMs. This supernumerary process will be continuous with the remaining service of the regularized and shall cease to exist. It is submitted that all the above steps to regularize are subject to concurrence of the so and so. It is humbly submitted that the indirect. So, my lord, this was the affidavit filed by them before the Supreme Court. Now, my lord, Supreme Court has taken into account this affidavit on while passing the order dated 14th of August 2023, page 109. My lord, relevant is page number 113, paragraph number 10, where the Supreme Court has reproduced the said paragraphs, my lord, with regard to regularization. Now, my lord, may kindly come to page 115, first line, because that was with regard to the order. It says the administration has requisite funds to the tune of rupees so and so under the wage head, which is under consideration before the Union Ministry of Home Affairs. Moreover, it has been stated that the regularization scheme would be framed in terms of the statement which was made before the division bench of the Honorable High Court. This has been clarified in the additional affidavit. So the court has taken note of the fact that the administration will promulgate a scheme in terms of the undertaking which has been given by the order of the division bench. Now, my lord, may kindly come to page 139. I'm sorry, my lord, page 125. Page 125. After the order of the Supreme Court, my lord, the administration has written a letter to the Union government. Page 125, my lord, dated 30th of August 2023. Now, my lord, may kindly come to page 129. Last two paragraphs. It says simultaneously multiple high-level committee meetings were convened under the chairmanship of Learned Attorney General of India in his office cum residence in New Delhi on 7th of August 2023, 10th of August 2023, and 12th of August 2023. Consequent to this meeting, Sri So-and-so, Attorney General of India, has advised as under. It says, categorical order should be issued for extending the benefit of 1/30th of a so-and-so. Formation of a scheme for regularization of casual labor DRM in accordance with DOPD dated 7th October 2020 with the following modification. Now, my lord, this advice was given stating that what all requirement or principle was there in the letter dated 7th of October 2020. Those principles has to be adopted by modifying. The only principle was borrowed, my lord, and it was modified to fix a cutoff date of so and so, my lord. Same thing what has been there in their affidavit. They have said it will make the very purpose of promulgating the scheme redundant, my lord. Only 10% will get, and therefore, my lord, this advice was accorded, and thereafter, my lord, kindly come to page 133. Last paragraph. On the other day also, I have shown it to my lords. In compliance with the order dated so and so by the Supreme Court in civil appeal number so and so. Now, my lord, kindly see, it says in compliance of the order of the Supreme Court. So and so, the administrator and read with the OM dated 7th October 2020, a scheme for regularization of service of has been drafted by this administration, which was approved in principle by the Honorable Lieutenant Governor, Andaman and Nicobar Island, subject to concurrence and ratification. So, my lord, two things I want to place before my lord, that the scheme was promulgated as per the advice of the Attorney General of India with modification. Secondly, in principle, the employer has given the approval. Page, my lord, 129 and 133.
And you may also come to page 129,
My lord.
the paragraph which you read, the third last paragraph.
My lord.
You may read that also. Meanwhile, in response to the administration's letter, this is also very important with
yes,
you.
which was sent to MHA, Ministry of Home Affairs has conveyed by letter dated so and so that the request of duty for allocation of funds for compliance with direction of the so and so has been noted by this ministry. The same will be included in the RPP proposal to be sent to the Ministry of Finance for the consideration during pre-budget discussion with Secretary.
Now, if you link this with the next paragraph,
yes,
simultaneously multiple high-level meetings were convened where, under the chairmanship of the Attorney General of India in his office cum residence in New Delhi. Obviously, then the ministry was involved in this.
Yes.
Union Ministry.
Yes.
So, two things. One, we see a connect between the Attorney General. He is a common thread in all this.
Yes.
He was representing the administration, Andaman administration, in the Supreme Court, before the Supreme Court, when that order was passed. Under his chairmanship, high-level committee was held in Delhi.
Yes.
With the Union Ministry.
Yes.
So therefore, this decision and the modifications are a result of those high-level meetings.
Yes, absolutely, absolutely.
So therefore, they cannot feign ignorance of this.
And more particularly, when on the August 3rd August order, this High Court has communicated the said order to all the ministry, my lord.
No, Mr. Kumar, we are distinguishing between mere communication stroke
My
knowledge
lord, they are not
with a decision, because they still had, as Mr. Sanjay rightly argued, that they have the purse strings. So they have the funds and it's their decision. May not be policy decision in that sense, but allocation of funds pertains to the entail to the executive's domain.
Right.
But after this, two things we find. Attorney General represented the administration, who was present in capacity of administration, and Attorney General was the person who was the chairman of these high committee meetings,
yes,
high-level committee meetings, and they suggested this modification.
Yes.
So therefore, it was akin to a decision being taken by the ministry.
Yes.
On their suggestion only, these modifications were incorporated.
And one more thing, my lord, it has a judicial color also. This everything was not an executive decision of the authority. This executive decision was based on an order passed by the judiciary. So it cannot be simply said to be an executive here. Now, my lord, so far as this fund part is concerned, as it has been fallen from my lord, let me, my lord, explain, my lord, with regard to fund. Now, my lord, here, since we are a union territory, if we want to create any post, then the administration will initiate a process with justification that these posts are required for the administrative requirement, and that will go to the ministry. Ministry will take a concurrence from the Department of Finance. Once the Department of Finance accorded concurrence, my lord, only thereafter posts are being created. Once the post is created, budgetary allocation every successive year are made.
But here it is not against the sanctioned post.
Absolutely against the sanctioned post. Absolutely against the sanctioned post.
All these DRMs are
absolutely, my lord.
And you have distinguished in the modified scheme also. There is a distinction between sanctioned posts and non-sanctioned posts.
Yes, my lord. They say that if it is
only the sanctioned post will be.
Yes, and they say, my lord, the rest of the employees, they will not be thrown out. They will be given exemption so far as if any recruitment process is initiated, they will give. Now, my lord, why I am saying, my lord, sees here, my lord may kindly visualize the situation that the administration did not have any source of revenue. So, my lord, if at all these daily rated employees, my lord, may kindly visualize the situation, 6,000 or 7,000 daily rated employees are working. Now, my lord, without the financial support of the union government, whether such payment could have been made by the administration? No. And therefore, my lord, when this post is created, because when it was sent with justification, ministry will take into account and thereafter it will be sent to the finance ministry, concurrence will be given, only thereafter post recruitment rules are being created. Now, my lord, as per my instruction, instruction, my lord, from at least from last 10 years, even the payment has been made under the heading, because the proposal which the administration is sending to the ministry is under the heading wages. My lord, those who are working on regular basis, their payment is made under the heading salary. And those who are working on daily rated basis, their payment is made under the heading wages. This is the proposal mooted by the administration before the ministry. So it is not that the ministry was not aware that these persons are working under the administration. Secondly, the fund which has been used for the payment of these daily rated employees is being provided by the ministry. And they are working against the post. I will show that there is a specific readings. The documents are there to show that the posts are lying vacant. Now, my lord, after this letter, my lord, there is two more letters of the ministry and administration. If my lord comes to 17th October 2023, my lord. 17th October 2023.
Yes.
Under page 139, it's a letter, my lord. It was written by the Chief Secretary of this island to the Ministry of Home Affairs. Now, my lord will find that, kindly come to page 140, my lord, second paragraph. It's a repetition, I am just placing it. Here it is pertinent to mention that as advised by the Attorney General of India, in the above matter, we have filed an affidavit before the Supreme Court stating that the administration in process of promulgating a scheme along with the broad contour of the proposed scheme. It was also submitted that the scheme will be subject to concurrence and ratification of so and so. The Supreme Court directed that all action in compliance shall be completed positively by 30th November 2023. That was the order of the Supreme Court. Given the above background and time, it is requested that further direction in the scheme may kindly be communicated. Now, my lord, may kindly come to those office memorandums, my lord, page 170. My lord, this is a office memorandum issued by the ministry whereby clarification was issued pertaining to implementation of the judgment of Uma Devi and HON'BLE Kesari. Only clarification to the extent. Kindly see, my lord. It says the undersigned is directed to say that the instruction for regularization of qualified workers appointed against sanction posts in the light of the so and so in case of were issued on 11th December 2006. My lord, that 6-month time which I have said, that 11th December 2006. Now, my lord, the above instruction as follows. Then it says according to a copy of this. So this was the government instruction. Para 2, it says in this regard various cases has been received in this department seeking clarification regarding implementation of the said judgment. It was only a clarification. Therefore, it has been decided that the further important aspect of the judgment may be for the purpose of clarity. So, this important aspect are equality of opportunity, the filling of vacancy cannot be done in a hazard manner. The state is meant by a model employer. Regularization is not and cannot be a mode of recruitment. So, this clarification was accorded by the ministry. Thereafter, my lord, ministry has also taken into account HON'BLE Kesari at page 172. Now, my lord, may kindly see para 4 once. It said it is also clarified that regularization circle was only a one-time exercise. Thereafter, it also emphasizes that all concerned administration authorities. My lord, so far as this one-time exercise is concerned, my lord, it has been diluted, my lord. Lastly, Santram, Narendra Dubey, in that case also, the Supreme Court has said it cannot be one-time exercise unless the last person, that is not relevant in our case, unless the last person in the said cadre is appointed, it can't be, my lord. More particularly in Santlal in 2019, the Supreme Court has said. So that is not our case, my lord. Now, my lord, para 5, it says it is also emphasis that all concerned administrative authorities should take steps to effectively defend the court cases on the basis of principle of so and so and instruction of BOPD within the limited period without giving any scope. So, my lord, this was a clarification how Uma Devi is to be implemented. Now, my lord, we kindly see the impute order, my lord. Page 148.
Underline.
148.
Yes.
Now, my lord, this is the order issued before the writ court, my lord. It says, I am directed to refer to your EO number so and so, dated so and so, on the subject cited above, and say that the proposal of Andaman Nicobar administration has been examined in this ministry and not agreed in the present form. As such scheme has to be formulated in consonance with clarification dated 7th October 2020, which retrieve the principles set forth in Uma Devi and Amal Kesari. Secondly, the OM dated 7th October 2022, referring in the above judgment of the Supreme Court, stipulate that the regulation exercise should consider all daily wages who are put in continuous service as on 10th April 2006. Thirdly, it has been mentioned by Andaman Nicobar administration in its proposal that a committee was constituted. Now, my lord, this malord may kindly record it. It says it has been mentioned by the Andaman Nicobar administration in its proposal that a committee was constituted by the Andaman Nicobar administration earlier also for formation of a scheme for regularization of DRM in Andaman Nicobar administration based on the recommendation of the committee. Service of 121 DRMs were regularized by the administration. As such, it appears that one-time exercise has already been done by the administration. This they say administration has submitted. I will place those documents. Now, my lord, the other important aspect of the judgment of the Supreme Court in case as follows: regularization is not and cannot be a mode of recruitment by the state. And my lord, the same thing which
So they're totally on Uma Devi.
Totally on Uma Devi. It is therefore for the administration concerned to take appropriate. Now, my lord, see. It is therefore for the administration ministry concerned to take appropriate decision in respect of the employees of such bodies as per the rule applicable to them. As per the Department of Finance, the draft scheme in its current form has the potential to impose heavy and long-term financial costs on the union. So, my lord, this was the ground. Now, the question which arises for consideration, my lord, that this order was passed, whereby the advice accorded, the scheme promulgated in advice of the Attorney General was negated. Now, my lord, may kindly see the justification which was given in this scheme. That has not been discussed. Why the advice cannot be taken into account? Those aspects simpliciter, they relied upon the judgment of Uma Devi and said that it cannot be done. Now they have to justify, my lord, the stand or the advice on the basis of which it has been scheme has been promulgated, my lord, that cannot be executable in ground. That is not there. They simply say, my lord, a advice by a person holding a constitutional post under the constitution. If you are saying that it cannot be, my lord, it's an advice rightly followed from my lord, but that advice was given by him under such circumstances. A duty is cast upon the ministry to say why such advice cannot be taken into account.
We are looking at it more seriously, Mr. Kumar, in your favor, because not only Attorney General, he may have an advisory capacity. We agree with that.
Yes.
It may be advisory.
Yes.
But that was the outcome of high-level committee meetings.
Yes.
In his residence in Delhi.
Yes.
Obviously, it was not in the islands.
Yes.
And he is an official. He's a spokesperson of the government, and he's also a constitutional authority, as you say. So, if meetings, high-level committee meetings, are held in Delhi, obviously the Union Ministry was directly involved.
Yes.
And the outcome of that was this suggestion of modifications by him, in terms of which the scheme has been created. Therefore, the Union Ministry cannot feign ignorance on this because of the high-level committee meetings.
Yes.
That part also we cannot overlook.
And apart from that, my lord, there must be a cogent reason. If there must be a cogent, my lord, first of all, they cannot approbate and reprobate, my lord. First of all. Secondly, my lord, if at all, by taking the ground that we were not a party, if they want to demonstrate something before the court by relying upon this order, then in that case, my lord, that order ought to have a reasoning that the said advice given by the Attorney General on the basis of which was it cannot be acted upon. And more so, my lord, that was not a simpliciter advice, that was on the basis of an order passed by the court of law. Now, my lord may kindly come to my writ petition, my lord. Paragraph number 44, my lord. At page 43 of the paper. Para 44. It says, your petitioner states that in input letter dated so and so, the respondent has contended that as per the respondent number 3, that draft scheme in its current form has the potential to impose heavy and long-term financial cost on the union government. In this regard, it is something that most of the daily rated employees for whom the said regularization scheme was promulgated by the Andaman Nicobar administration are working against the sanctioned vacant post. Only in the Andaman Public Work Department, there are more than 2 to 5 posts lying vacant against which the daily rated employee are working. Apart from the said department, even in other department under the Andaman Nicobar administration, about 1,000 posts are lying vacant against which the daily rated employees are working. Now, my lord, here we have given the document also, my lord. My lord, may kindly come to page 176. This was obtained under Right to Information Act. Details of work charge post under APWD. It consists of 2 pages, my lord. Page 177 gives this clear picture, my lord. 4245. Now, my lord, can you see their reply at in the second paper book, page 206 of the ministry, para 41. Para 41. They say the content of need to be corroborated by respondent number 4 as they are the custodian of record for the same. Now, my lord, may kindly see the affidavit of in opposition of the administration at page 334. They said admitted to the extent borne by record. Paragraph number 6, my lord. Save what are matter of record. And my lord, we have placed the record. Save what are matter of record and save as would appear therefrom, so far as any allegation contained in para 17, 44, 45, and so against the answer are denied and disputed. So, what are matter of record? My lord, we have placed the record obtained under Right to Information Act. They don't deny the existence of the said document or the factum that no such post is lying vacant or these daily raters are not working against the said post. Now, my lord, in my readings at page 50, para 54 onwards, 54 to 58, I have stated what was the requirement for the administration, why administration has engaged this person. Para 54 to 58. It says, my lord, that the entire administration is facing acute shortage of manpower, and without these daily wages employees, workers, the entire administration will get paralyzed and the holistic development exercise of the government of India. Page 40. Exercise of the government of India will be hampered badly as such the respondent ought to have accorded approval to a scheme so and so. Thereafter, my lord, that considering the necessity of workers, the administration engage the daily regular and continue their service for long so that the administration can perform its duties as per the direction received by the administration from government of India from time to time. That the appointment of the daily regular is casual, but their service are not casual. They are performing the duties at par with the regular employee. Thereafter, my lord, that the regularization was put by the administration considering the necessity in consultation with the so and so with and with good motive. Your petition states that the daily rated employee who are working under the administration for years together discharging the duties and responsibility of regular regular employee, and in terms of the order of the Honorable Division Bench of this Honorable Court, the Andaman Nicobar Administration, considering the length of service rendered by the said daily rated employee, promulgated the said scheme. Presently, all the said daily rated employees whose case was considered by the administration for our overage having their respective family, this and that. Now, my lord, how they have dealt with it. My lord, can you see? My lord, may kindly come to para 47 of their reply. 45, my lord. Page 207 of the ministry.
Yes.
It says that the content of para 54 to 58 are wrong and denied. It is submitted that it has no legal basis for the demand in terms of the factual position enumerated. This is the reply. These are the two foundations so far as my writ petition is concerned. First, they are working against the sanction post. There are several vacant posts lying. Secondly, my lord, that these are the requirement because of which they were engaged, and the work of the administration would be paralyzed if this person's. And my lord, this is practically an unfair labor practice, my lord. Now, my lord, so my lord, my contention is that, my lord, that a post was created. The administration has mooted the proposal with justification. After the concurrence of the finance, the posts are created. There are sanction posts. So one sanction post yearly budgetary allocation is made by the ministry. And on the basis of that, the payments are made to them under the head wages, not as salary. So the entire fund was borne by the ministry. Now, after the order of the court, all of them are getting 1/30th of pay. That is the minimum of the, my lord, the regular employee. And plus DMS allowances they are getting. So, my lord, this fund part also, my lord, that cannot sustain because today they are getting at least 75% of the salary of the regular employee. They are getting, my lord, 30 odd thousand, regular employee gets 40 odd thousand. Now, my lord, these are on facts, my lord. Now, my lord, I am relying upon the judgments, my lord. My lord, these judgments are pertaining to regularization. And my lord, I respectfully submit, my lord, these three exceptions which has been made out by the, in the case of Uma Devi, my lord, I will show after reading all the judgment, my lord, it will be crystal clear that Supreme Court said sanction post is not required. Supreme Court said there would be no cut-off date because the engagement which were made in the year 2004, that has been regularized. Thirdly, the Supreme Court said for discharging a duties of sweeper and all, minimum qualification is also not required. I will show from the judgments, my lord. And my lord, so far as financial implication, my lord, in one of the judgment, the first paragraph starts with that. I will place those judgments. Now, my lord, may kindly come to first judgment, my lord. This is of 2015, my lord, para 14, my lord, my lord, I will not bother, my lord, to see all the judgments. My lord, may kindly come to serial number 2 that starts from page 7. Relevant page would be page number 8. I have highlighted the page, my lord, which I intend to rely. Para, I am sorry. Para. My lord, may kindly come to page number para 8, my lord. Page number 9.
Yes.
It says, when we consider the prevailing scenario, it is painful to note that the decision in Uma Devi has not been properly understood and rather wrongly applied by various state government. We have called for the data in the instant case to ensure as to how many employees were working on contract basis or ad hoc basis or daily wages basis in different state department. We can take judicial note that widely aforesaid practice is being continued. Though this court has emphasized that the incumbent should be appointed on regular basis as per the rule, but new devices of making appointment on contract basis has been adopted. Employment is offered on daily wages basis, etc. in exploitative forms.
This is what you told Mr. Sanjay also.
Yes, sir.
This is being taken advantage of by all government.
Yes, all government and the, my lord, the judiciary has taken note of it, my lord. Now it says this situation was not influenced by Uma Devi Supra. The prime intent of the decision was that the employment process should be by fair means and not by backdoor entry and in the available pay scale. The spirit of Uma Devi has been ignored and conveniently overlooked by various state government authorities. We regretfully make the observation that Umadevi has not been implemented in its true spirit and has not been followed in its pith and substance. It is being used only as a tool for not regularizing the service of the incumbents. They are being continuing service without payment of due salary for which they are entitled on the basis of Article 14, Article 16, with Article 34 1D of the Constitution. And if they have no constitutional protection as invest in DS and so from cradle to grave in heydays of life, they are serving on exploitative terms with no guarantee of livelihood to be continued, and in old age they are going to be destitute. There being no provision for pension, retirement benefit, etc. There is clear contravention of constitutional provisions and aspiration of downtrodden classes. They do have equal rights, and to make them equal, they require protection and cannot be dealt with arbitrarily. The kind of treatment meted out is not only bad, but equally unconstitutional and is denial of rights. We have to strike a balance to really implement the ideology of Umadevi. Thus, the time has come to stop the situation where Umadevi Sutra can be permitted to be plotted, whereas this court has interdicted such employment way back in the year 2000. This employment cannot be on exploitative terms, whereas Umadevi laid down that there should not be backdoor entry, and every past post should be filled up by regular. But a new device has been adopted for making on payment of paltry system on contract ad hoc basis or otherwise. This kind of action is not permissible when we consider the business substance.
Difficulty, Mr. Kumar, is that backdoor is the only door which is being opened to this unorganized sector.
My lord.
So if that is the only door,
yes,
then that has to be constituted to be the main door.
I'm grateful.
Because we are seeing that every day in everyday life also. Yes. Wherever you go, any employment, any government, not only one, not two governments.
And my lord, this is the this I want to show. Now, my lord, can you
so this is the dilution of Umadevi,
yes,
in a sense.
Yes, I am just showing that only.
Yes.
Now, thereafter the judgment, page 11, my lord. And my lord, those judgments which my learned friends rely, I have prepared a note. Those judgments are not applicable in these cases. And furthermore, those judgments are old judgments, my lord, 2006, 7, and I am showing those judgments which are in 23, 24, and 25. Most of the judgments. Now, my lord, may kindly see. This was passed on 30th of January 2024. It starts from page 11, paragraph number 5 and 6. Page 14, my lord.
Yes.
It says, having heard the argument of both the sides, this court believes that the essence of employment and rights thereof cannot be merely determined by the initial term of appointment, when the actual course of employment was evolved significantly over time. The continuous service of the appellant in the capacity of regular employee performing duties indistinguishable from those in permanent post and their selection through a process that mirrors that a recruitment regular constitute a substantive departure from the temporary and scheme specific nature of their initial engagement. Now, my lord, may kindly see.
So the mirrors regular recruitment is probably not applicable, but
it is not applicable.
But insofar as against sanction post, that is one of the yardsticks.
Yes, my lord. And in para 6, they have dealt with Umadevi, my lord. In all those cases, my lord, Umadevi has been dealt with by the Supreme Court. It says the application of the judgment in Umadevi by the High Court does not fit squarely with the facts at hand. Giving the specific circumstance under which the appellant were employed and have continued their service, the reliance on procedure formality at the outset cannot be used to perpetually deny substantive right and has accrued over a considerable period through continuous service. Their promotion, it was pertaining to some promotion, my lord. But this is the crux, my lord, which I want to before this wanted to go. Now, my lord, may kindly come to this judgment of Jaggu, my lord. Here, there are several paragraphs which are very vital. It starts from page 36. First, paragraph number 10. My lord, here, these persons were, my lord, once see para 4, some of them were appointed in the year 93, para 4, my lord. Just in order to say that the cutoff date will not come into play. 98, 99, 2004. Appointments were made. Para 4, the date is given. Now, my lord, kindly come to paragraph number 10. My lord, here, if my lord sees in para 7 at page 41, Uma Devi was taken into account, my lord. Now, my lord, may page 42, para 8, my lord, the argument which has been advanced by the petitioners under different heading, my lord. Continuance of nature of duty, absence of performance. Now, my lord, at page 43, subclause 4 says compliance with Uma Devi guidelines, and thereafter discrimination in regularization. These all aspects were argued, and page 44 says equity and fairness. My lord, the stand taken by the authorities in para 9 is at page 45. Nature of engagement, absence of sanction post, non-compliance with Uma Devi criteria, educational qualification, outsource as a legitimate policy decision, no fundamental right to regularize. So these were the ground taken. Now, my lord, may kindly come to para 10. Page 47.
Yes.
Having given careful consideration to the submission advance and the material on record, we find that the appellant's long and uninterrupted service for period extending well beyond 10 years cannot be brushed aside merely by labeling their initial appointment as part-time or contractual. The essence of their employment must be considered in the light of their sustained contribution, the integral nature of their work, and the fact that no evidence suggests their entry was through any illegal or superfluous route. The appellant throughout their tenure were engaged in performing essential duties that were indispensable to the day-to-day functioning of the office of so-and-so, as Safai Wala so-and-so were responsible for maintaining hygienic, cleanliness and conduct working environment within the office premises. Their duties involve sweeping, dusting so-and-so member, a set of responsibilities that directly contribute to the basic operational function of the so-and-so application of so-and-so member. Para 12, despite being labeled as part-time workers, the appellant performed this essential task on a daily and continuous basis for an extensive period, ranging from over a decade to nearly 2 decades. This engagement was not sporadic or temporary in nature. Instead, it was recurrent, regular, and akin to the responsibility typically associated with sanction posts. Moreover, the respondent did not engage any other personnel for this task during the appellant's tenure, underscoring the indispensable nature of their work. Thereafter, my lord, para 13. The claim by the respondent that they were not regular posts lacks merit, as the nature of work performed by the appellants was perennial and fundamental to the functions of the office. The recurring nature of this duty is necessity their classification as regular employee, irrespective of how their initial appointments were labeled. It is also noteworthy that subsequent outsource of this so-and-so tasking to privilege agency after the appellant's termination demonstrate the inherent need of this service. This act of outsourcing so-and-so. Thereafter, my lord, paragraph number 16, my lord. The appellants consistent performance over their long tenure further solidifies their claim for regularization. At no point of time during their engagement did the respondents raise any issue regarding their competence or performance. On the contrary, their service were extended repeatedly over the year, and their remuneration through so-and-so, which was an impact acknowledged on their satisfactory performance. The respondent belated plea of alleged unsatisfactory service appears to be an afterthought and so. Now, my lord, may kindly come to para 20 is very vital, my lord. My lord, may kindly come to paragraph number 20. It is well established that the decision of Uma Devi Supra does not intend to penalize employees who have rendered long year of service, fulfilling the ongoing and necessary functions of the state or its instrumental. The said judgment sought to prevent backdoor entries and illegal appointment that circumvent constitutional requirement. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period. The concept of sanctioned post was taken away by the Supreme Court, saying that sanctioned functions which are being discharged by them for a considerable period, the need for a fair and human resolution becomes paramount. prolonged continuation and unpleasant service perform tasks inherent requirement on a regular basis can over the time transform what was initially ad hoc or temporary into a scenario demanding fair regularization. And thereafter, my lord, the second judgment which I have relied, the court has relied para 6 of the said judgment. Thereafter, my lord, para 21. The High Court placed undue emphasis on the initial label of the appellant. Engagement and the outsourcers decision taken after their dismissal. Court must look beyond the surface label and consider the realities of employment. Continuous long-term service, indispensable duties, and absence of any bona fide or illegality in their appointment. In that light, refusing regularization simply because their original term did not explicitly state so, or because an outsourced policy was belatedly introduced would be contrary to principle of fairness and equity. Now, my lord, thereafter, para 22, the pervasive misuse of temporary employment contract as exemplified in this case reflects a broader systematic issue that adversely affect workers' right and job security. In the private sector, the rise of so-and-so, my lord, may kindly come to next page, second line onwards. Such practice has been criticized for exploiting workers and undermining labor standard. Government institution entrusted with upholding the principle of fairness and justice bear an even greater responsibility to avoid such exploitive employment practice. When public sector entities engage in misuse of temporary contracts, it not only mirrors the detrimental trends observed in the gig economy, but also sets a concerning precedent that can erode public trust in government operation. Thereafter, my lord, the International Labour Organization, of which this aspect has been taken into consideration by the Supreme Court. Now, my lord, with these two paragraphs 23 and 24, my lord, now we kindly come to para 25. It says, my lord, it is disconcerting reality that temporary employees, particularly in government institutions, often face multiple forms of exploitation. While the foundation purpose of temporary contract may have been to address short-term or seasonal needs, they have increasingly become a mechanism to evade long-term obligation owed to employees. This practice manifests in several ways. Misuse of temporary labels. Now, my lord, it has been thereafter, my lord, arbitrary termination. Thereafter, lack of career progressive. Thereafter, my lord, using outsource as a skill, denial of basic right and benefits. While the judgment, now my lord, para 26 again Uma Devi was taken into account. While the judgment in Uma Devi Supra sought to curtail the practice of backdoor entries and ensure appointments adhering to constitutional principle, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claim of long-serving employees. This judgment aimed to distinguish between illegal and irregular appointment. It categorically held that employees in regular appointment who were engaged in duly sanctioned posts and had served continuously for more than should be considered for regularization as a one-team measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claim of employees, even in cases where their appointment are not illegal but merely lack adhere to procedure formalities. Government department often cite the judgment of Uma Devi to argue that no vested right to regularization exists for temporary employees, overlooking the judgment's explicit acknowledgement of cases where regularization is appropriate. This selective application distorts the judgment's spirit and purpose, effectively weaponizing it against employees who have rendered indispensable service over decades. In light of this consideration, in our opinion, it's imperative for government department to lead by example in providing fair and stable employment. In engaging workers on a temporary basis for extended period, especially when their roles are integral to the organization functional and not only contravene international labor standard, but also exposes the organization to legal challenge and undermines employees' morale. By ensuring fair employment practice, government institution can reduce the burden of unnecessary litigation. My lord, so my lord sees this judgment. Many of the aspects, my lord, which they intend to argue before this court has been dealt with. Now, my lord, may kindly come to another judgment. My lord, this is again in 2024, page 65 onwards. My lord, I will straight away take my lords to para 9. Page 69.
Yes.
It says, my lord, it is again a case of regularization. I am not bothering, my lord. My lord, it says, be that as it may be, neither the 15 incumbents lecturer nor the respondent suffer because of the internal squabble between the petitioner and the UPSC. The decision of State of Karnataka, Uma Devi, as held in a recent decision of Sripal, I will also cite Sripal, my lord. Sripal cannot be used as a shield to justify. Page 69.
Yes.
It says, my lord, the Uma Devi cannot, as held in the recent judgment, cannot be used as a shield to justify exploitative engagement, persistently for a year without the employer undertaking legitimate recruitment process to deny relief of regularization. Now, my lord, may kindly come to next statement, my lord, which I am relying is Sripal, my lord. My lord, may kindly come to page 72 onwards. The relevant paragraph is paragraph number 5. Paragraph number 5. Page 77.
Yes.
Now, my lord, the argument of the workman, my lord, continuous service, direct engagement, illegal termination, my lord, during the pendency of the some cases which were filed by the workers, they were illegally terminated. Entitlement to reinstatement and regularization.
So we come straight away to 4, Roman 4.
Roman 4, my lord. Roman 4 is my case. Even there, this was the argument advanced, my lord, and thereafter the stand taken by the authorities at paragraph number 6. They say compliance with constitutional requirements, no direct employer-employee relation, thereafter Uma Devi, and thereafter inadequate proof of work, my lord. Here, my lord may kindly come to paragraph number 12, my lord. At page 86, my lord.
Yes.
It says, my lord, that evidence including documentary material and undisputed facts reveals that the appellant workman performed duties integral to the respondent's employer municipal function, specifically the upkeeping of parks, horticulture tasks, and city beautification. They were working in a horticulture section of the municipality. Such worker is evidently perennial rather than sporadic or projected based. Reliance on a general ban on fresh recruitment cannot be used to deny labor protection to long-serving workmen. On the contrary, the acknowledgement shortage of gardener in the so-and-so method. Thereafter, method will kindly come to paragraph number 14. The respondent employee placed reliance on Uma Devi.
We have read this paragraph.
Well,
this was quoted in Justice Doctor's judgment also.
Yes, my lord.
And the previous judgment.
Yes, yes, my lord.
We have read it.
Now, my lord, para 15, my lord.
Yes.
It is manifest that the appellant workmen continuously render their service over several years, sometimes spanning more than a decade. Even if certain muster rules were not produced in full, the employer's failure to furnish such record despite direction to allow an adverse interest, so and so, morally and legally, workmen who fulfill ongoing municipal requirement cannot be dismissed summarily, so and so. Now, my lord, can you come to para 18, madam? Page 18, subclause 4, my lord. 18, it starts from page 92, my lord, can you come to page 93? This is the, my lord, allowed, and the court said the respondent will be directed to initiate a fair and transparent process of regularization within 6 months from the date of duty, considering the fact that they have performed perennial. My lord, in all these cases, my lord, direction for regularization was given by the Supreme Court, my lord. Now, my lord, now the other judgment is of Dharam Singh, my lord. My lord, may next page, my lord. My lord, may kindly come to first paragraph, my lord, at page 95. This is of 19th August 2025. Now, my lord, it says when public institution depends day after day on the same hand to perform permanent tasks, equity demands that those tasks are placed on sanction posts, and those workers are treated with fairness and dignity. The controversy before us is not about the rewarding irregular employment. It is about whether years of ad hoc engagement depended by shifting excuses and pleas of financial strain can be used to deny the right of those who have kept public institution running. This was the issue, my lord. Paragraph number 3, my lord. It says, by the impute order, the division bench affirmed the decision, dismissal of the writ petition on the premises that appellant were engaged on daily rated basis and there were no rule in so and so for regular. Moreover, the court observed that no vacancy exists against when the appellant could be considered. Now, my lord, can you see para 4 onwards, my lord? 4.7, my lord. 4.7 again my lord Uma Devi was taken into consideration, and thereafter my lord we kindly see para 6. The question before us at page 99, whether the High Court erred in failing to adjudicate the appellate principal challenge to the state refusal to sanction post and treating the matter as a mere plea for regularization. Now my lord may kindly come to paragraph number 11. Here Uma Devi has been dealt with. 103.
Yes.
Furthermore, it must be clarified that the reliance placed by the High Court on Uma Devi to non-suit the appellant is misplaced. Unlike Uma Devi Supra, the challenge before us is not an invitation to bypass the constitutional scheme of public employment. It is a challenge to the state arbitrary refusal to sanction post despite that the employer own acknowledgement of need and decades of continuous reliance on the very workforce. On the other hand, Uma Devi draws a distinction between illegal appointment and irregular appointment.
Judgment Shripal has been
relied upon. And my lord, here the court said some stringing order is to be passed. The court said through within this period to this period. And here also we have passed order. We are not complied with this. All aspects were taken into consideration, my lord. 19.2, if my lord sees financial page 130, that has been dealt with.
yes.
Financial consequences and areas, how to make the payment and all. And thereafter, my lord, the court directed them to file an affidavit after compliance, page 114, Roman 5. And para 20, my lord, the court says we have framed this direction comprehensively because case after case orders of this court in such matter has been met with fresh technicality, rolling reconsideration and administrative drift which further prolong the insecurity. My lord, court has taken all the aspects in this judgment, my lord. Now, my lord, may kindly see the last judgment of 30th January 2026, my lord. It is at page 136, my lord. My lord, we kindly come to para 11. Yes, my lord. It is pertaining to this bargaining power. How far a employee? Paragraph number. My lord, para 8 issues were framed. Page 145. Second issue is the Y2 one. 145. Whether the inaction of the respondent state did not recognize the applicant's continuous service for the purpose of regularization is arbitrary and violative of Article 14 of the Constitution. Now, my lord, may kindly see paragraph number 11, my lord. At page number 151,
yes.
last paragraph.
Yes.
State as a model employer. At the outset, we find it necessary to express our disapproval of the manner in which the High Court has approached the present list. The controversy before the court was not one of mere acquisition or implied waiver of rights. The High Court, in our opinion, has proceeded on a mechanical application of precedents without engaging with the core constitutional issue involved, thereby reducing the dispute to one of acceptance of contractual terms diverse from its larger constitutional context. This court has consistently held that the state, being a model employer, is saddled with a highest obligation in the discharge of its function. A model employer is expected to act with high probability, fairness, and control, and bears a special responsibility to treat its employee in a manner that preserves their dignity. The state cannot be permitted to exploit its employees or to take advantage of their vulnerability, helplessness, or unequal bargaining position. It is therefore follows that the state is required to exercise caution in its role of an employer. The constitutional mandate casting upon it a strict obligation to act as a model employer, an obligation from which no exception can be countenanced. In the thereafter, my lord, 11.5, my lord. Article 14, my lord.
Negative equality.
Yes. And thereafter, my lord, page 155, my lord.
Yes.
Paragraph number. It is
continuation of 30.
Continuation of paragraph. Therefore, this court has held that the constitutional obligation courts to advance social and economic justice and to give effect to the equality mandate under Article 14. Consequently, court will neither enforce nor hesitate to invalidate contracts or contractual clauses that are unfair or unreasonable when entered into between parties with unequal bargaining power. And thereafter, with regard to bargaining power, my lord, in 156 also the court has said it's clear that the court are empowered. Now, my lord, can you see 156? Therefore, it is clear that court are empowered to invalidate unconscionable elements of a contract where the parties lack the ability to exercise any real or meaningful choice in negotiating in terms. In the present case, the appellants were left with no other alternative but to accept the condition unilaterally prescribed by the respondent state in order to secure their livelihood and sustain a source of income. It would be entirely unrealistic to assume that in such circumstances, an employee seeking temporary employment could meaningfully negotiate or assert a position against the overwhelming might of the state machinery.
Back door is the only door.
Yeah. Now, my lord.
Yes.
12.2, it says at this junction, the analogy of, my lord, this was with regard to bargaining power, my lord. My lord, can you see 12.3 is very relevant. At least, my lord, after 6 lines, we have no hesitation in holding that the constitutional court are duty bound to act to safeguard those who are vulnerable to exploitation, so that the employees are not compelled to legally submit to the demands of a vastly dominant contracting party like the state, but are instead assured that constitutional protection will never intervene to prevent such exploitation. Thereafter, 13 also, my lord, another fact, reconsidering the case of contractual employees such as the present appellant is the doctrine of legitimate expectation. That was also dealt with by the Supreme Court, my lord, with regard to legitimate expectation, where employees have continued to discharge their duties on contractual posts for a considerable length of time, as in the present case. But it is but natural that a legitimate expectation arises that the state would at some stage recognize their long and continued service. It is in this belief, bolstered by repeated extension granted by the executive, that such employees continue in service and refrain from seeking alternate employment, notwithstanding the contractual right of their engagement. At this juncture, is thus opposed to advert to the principle governing the doctrine of legitimate. My lord, even if there is a contract which says that it cannot be regularized, then also, my lord, there is a legitimate expectation that the state.
There is a contra argument that legitimate expectation must be based on right, which has been dealt with here.
Yes.
Must be based on a right, and there has to be an implied promise at least.
Yes.
So here, the right under Article 14, the negative equality has been elevated to a fundamental right.
Yes.
And that has been held to be the right which creates a legitimate expectation.
Yes, absolutely.
As well as the implied promise in engaging you year after year after
year. After that was exactly dealt in para 13.
Yes. Army welfare was considered, and these
yes.
aspects were
considered. This was in elaboration.
Not in so many terms, but previously it has been elevated. Negative equality has been.
Yes, that was there. Thereafter, my lord, there are. My lord, 160 Umadevi was considered. My lord.
Yes.
However, the court in Umadevi clarified that the so and so.
Umadevi has to be overcome in nature.
Yes.
Otherwise, you cannot hold those things. Yes.
In all the judgment, my lord, Umadevi was considered, and my lord, I have said at the inception itself, all the 3 parameters which were fixed by Umadevi, the court in this judgments has said that that was not the requirement. If my lord sees, so far as the date that 1/4/2006 would be the cutoff date, I have shown from my lord Jagu's judgment, where engagement was made after.
That is precisely what we pointed out to Mr. Sanjay, who is now here, that Umadevi has been used to give only contractual employment.
Yes.
No permanent.
And my lord, in para 13.7, my lord, Umadevi was once again taken into account, my lord. It says it was held that Umadevi cannot be employed as a shield to legitimize exploiting engagement continue for a year without undertaking regular recruitment. The court further clarified Umadevi itself draws a distinction between illegal and irregular appointment. And my lord, this Dharam Singh and all were taken into account, my lord. My lord, one more judgment is there. This is all. 16th March 2026.
Yes.
My lord. My lord, this is para 9. Page 171. Para 9, my lord. Page 171.
Yes.
It says, my lord, the impute judgment of the High Court, the learned counsel for the petitioner submitted that the High Court has overlooked that there was no dispute that those workmen were rendering service since 93 and their service were dispensed with in truth of such long continuation in service raised a presumption regarding existence of a regular vacancy as also that the job is perennial in nature. only on this proposition, my lord. Para 11, my lord, we have accorded due consideration to the so and permissible of the so claim that the written statements those workers were engaged. So this inference was drawn by the court. Ultimately, the court has allowed, my lord, and directed. This was with regard to illegal termination, and the court directed reinstate. But the principle which has been laid down in para 9, my lord, that non-serving, assume that there is a vacancy and perennial nature of job.
Para 13, there is something against you. Para 13, there is something against you that this is contrary to what Justice Vikramnath held in the previous judgment.
In a case where engagement is for substantive length of time.
No, para 13. Para 13, page 175.
Hello.
We are conscious of the law that the burden to prove that a workman had worked continuously is on him.
Yes.
So this is somewhat contrary to Justice Vikramnath's observation that adverse inference can be drawn against the employer.
So,
but this is diluted, and your scheme probably takes care of that.
Yes.
I mean, draws a distinction between people who are working.
Yes,
there is something there. So therefore, the scheme cannot be brushed aside on that ground.
And without assigning any reason, my lord.
What do you do? Consistently. Yes.
My lord, these are the judgments on regularization. Now, my lord,
another set of judgments.
My lord, this is short, my lord, with regard to Article 14 and the power. Only the 3 judgments I have relying, my lord.
Yes.
My lord, may kindly come to the first judgment at para 20, my lord, at page number 9.
Yes.
It says, my lord, there is thus no doubt that the High Court in page 9.
Yes.
It says, thus there is thus no doubt that the High Court in India, exercising their jurisdiction on Article 226, have the power to issue a writ of mandamus or a writ in the nature of mandamus or pass orders and give necessary direction, where the government or a public authority has failed to exercise or has wrongly exercised the discretion conferred upon it by a statute or a rule or a policy decision of the government, or has exercised such discretion bona fide or on irrelevant consideration, or by ignoring the relevant consideration and material, or in such a manner as to frustrate the object of conferring such discretion or the policy for implementing which such discretion has been conferred. In all such cases, my lord, because here it is a case, my lord, where the decision was arrived ignoring the relevant consideration, my lord. So therefore, this court can, my lord, I have relied upon para 20, 38.
But it is in a specific context. Lowering standard for candidates, relaxation, schedule ka schedule type.
My lord. And lastly, that decision, my lord. Thereafter, my lord, one more judgment, though it's not required, with similar preposition, my lord.
Star Enterprise.
Yes, my lord. Star Enterprise. My lord, para 7, my lord.
Yes, yes.
I said we do not find difficult to agree, Mr. So and so, that response number 1 is a state within the meaning of Article.
This is not applicable exactly, because this is commercial trading activity. It has said it is not commercial activity. And these are general propositions. These are well accepted.
Yes, well accepted.
Even the union and the state won't oppose these. I mean, general principles 226, Article 12. These are definitely there. That's what Article 26, 226 is there for.
And my lord, only one thing, my lord.
Yes.
I have cited one more judgment at page 24, which says, my lord.
Yes.
Unless, my lord, because it's an intra-court appeal, unless, my lord, find that there is perversity in the order of the writ. Though this judgment, my lord, will ignore.
So why should we ignore? Yes.
But I say, my lord, it's an intra-court appeal.
So definitely the scope is very limited.
Unless, my lord, arrive to a definite finding that there is a perverse in the order of the writ court.
Yes.
My lord.
Which paragraph particularly?
My lord, 4th. Paragraph 4.
This is also settled.
Yes,
the court will.
These are the judgment, and my lord, thereafter I have not cited this Ramana Dayaram Shetty, my lord, which deals with Article 14 and Kanika Gandhi, both Article 14. these are the judgments which were cited.
How many
by
more
them.
sets?
No, they have cited.
Oh,
I have
thank
dealt with their judgments. my lord.
Yes.
Now, my lord, will find this judgment, my lord, in my serial number 1. I have given their serial number at the right hand side. It was their serial number 4. My lord, this judgment is pertaining to an aided hostel. The facts are aided hospital, I have said so, my lord, which is not governed by the statutory rule framed by the. They were employed as part-time cook chowkidar in the said hostel. As such, the case was dismissed. So that has got no parallel. If my lord sees, the facts are entirely different. Thereafter, my lord, this judgment, they were part-time, only for some hours they have worked. So they were seeking the benefit of Uma Devi, that has been dismissed. Thereafter, my lord, third judgment, my lord, he was appointed by an incompetent authority. So he did not have the power to appoint. These all were the grounds. Thereafter, my lord, this fourth judgment is with regard to retirement benefits. The facts are with regard to retirement benefit, fourth and fifth one. Thereafter, my lord, sixth judgment, my lord, there, my lord, the company was facing financial hardship. Under such circumstances, when 10 compassionate appointed persons seek for regularization, that was one of the considerations that if the company is going to be closed, that was the situation, and the matter was pending before the Board of Industrial and Financial Reconstruction. How the company can be able to run with minimizing the staff. These all are the facts, my lord.
We hope this does not apply to the union government. This logic.
My lord.
You can only hope this logic does not apply to the union.
Yes, yes.
Sanjay will be able to say that.
Yes, yes, yes.
Facing financial hardship and
there is no scope, my lord.
going to be closed.
65% they are paying.
Going to be closed and all. Yes.
Yes, yes.
So yes, next.
So, my lord, these are the other case, my lord. There was a public interest litigation wherein, my lord, some
District judiciary.
District judiciary, there was a direction issued in a public interest litigation which was altogether for different aspect. There, the court directed to regularize the service of 209 daily rated employee. There, the Supreme Court said, since already the process is pending before the state, and the state has to ascertain whether it was illegal appointment, illegal appointment. This all aspect, and therefore, my lord, this was not considered. And therefore, that direction for regularization was held because it was under consideration before the state government. Altogether, the state was considering regularization of 61,000 persons. So, and the issue was unconnected. My lord, here the next judgment is with regard to the employment of 2 daily rated employees. Here, what happened, my lord? Once disengagement was held to be correct because from section 25P and all, and the other, my lord, the court directed regularization on the premises. That in terms of the circular, the other employees who were engaged and along with it, they were given regularization. Therefore, the court said reinstate him and regularize him. There were 2 employees. So far as one employee is concerned, his case was negated. So far as the other, the court found that there is a discrimination. So those are not akin to the facts of our case, my lord. And this the 9th judgment, my lord, this is with regard to border road organization. There was a contention that there was a break in service, and they were seeking regularization. My lord, there the employees relied upon 2 internal communication, my lord, between the state and the border road organization, and which was not approved, and therefore on the said premises it was rejected. And the other one is with regard to the engagement of the daily rated employees in corporations. And after working for a considerable period, they raised the industrial dispute. My lord, when the matter traveled to Supreme Court, the Supreme Court held that the corporation is being funded by the state government. And if the scheme is promulgated, then it ought to be with the approval of the state government. And further, the appointment of the incumbents were not by complying Article 14 and 16. My lord, 11th judgment, my lord, this judgment says, my lord, they were appointed for a project. The purpose for which their appointment was made, project was over. They were thrown out. They filed a case for regularization and seeking equal pay for equal work. That has got no manner of application. Thereafter, my lord, the 12th judgment, my lord, that deals with part-time employees. There, the Supreme Court held that only continuing in service did not call for regularization when they were not working against a sanctioned force. therefore negated. This judgment was passed in 2014. Thereafter, my lord, again, para 13 deals with a case where a person was appointed in a research project. Research was over, so he was thrown out of service. Then they approached the Honorable High Court and matter traveled to Supreme Court. Supreme Court remanded back the matter. The right of the parties were not decided. My lord, our written notes I am just handing out.
Yes, Mr. Sanjay, can we come to you?
Milords, before I
Yes, you want something. Yes, yes, Mr.
before I
I would say there is no scheme break. There is no order of the court. Whether the court are powerless to pass an order. That
Milords, before Milord I start my rejoinder, Milord, I will seek your lordship's indulgence, Milord, that Mr. Natraj is connected. Milord, there was some communication gap that and his Milord network was Milord, there is some problem in Supreme Court with respect to the network.
Yes.
He had certain problems, even though he was looking to be connected, but then thing was not very clear. So I have
We still don't find him.
Sorry.
We still don't find him on the screen.
No, Milords, he's there, Milords. He's there.
Yes, oh, yes, come
So,
after.
Lordship may hear him, and thereafter I will make my rejoinder, Milord, subject to your Lordship's convenience.
Very good. Yes, Mr. Natraj.
Yes, please. So some communication gap from the department side in the matter. So inconvenience is caused, please.
Yes.
Now, kindly.
Administration, right, Mr. Natraj?
Yes, administration.
Yes. Yes.
Now, kindly take the prayer sought in the writ petition. The present proceedings, which we get at page number 298.
Apparently, all of them are rely on the writ petition.
Yes.
No, you don't have a copy of the paper books, Mr. Natraj?
Achha, my briefing counsel must be.
So far as the copy of the paper book is concerned, Milord, we have the writ petition, etc. The compilation which was filed by the opposite side, Milord, is not with us, Milord. Because of the distance, there is some Lordship.
Too difficult. Yes, we'll take up the request. Page number, yes. If Mr. Natraj, you go on just indicating the page number of the writ petition.
Yes, that's a page number 64, if I'm right. That's a prayer column is available at page number 64, internal page 64.
We'll just correspond with the paper.
Yes.
Page 64 of the paper book, right?
Yes. Of WPA 547 of 24.
The prayer in the writ petition?
That's right. Prayer in the writ petition.
Yes. We've got it.
Actually, very candid. Actually, we were, myself and Sanjay, we are hoping it would be better to be present in Andaman and have some argue the matter. That was
much better, we can assure you.
Yes. We look forward. Kindly turn to page number 290. That's the internal page for prayer at page number 64.
Right.
So the first prayer is written in the nature of mandamus, setting aside the impugned letter dated 13/12/23 issued by the respondent number 1, whereby by taking into consideration the office memorandum dated 7/10/20 stated that respondent number 2 does not have any such scheme for regularizing of service of persons not following due process of law against unsanctioned post, nor is there any scheme under the consideration of the government, and the respondent number 2 has advised the administrative ministry concerned to take appropriate decision in respect of the employees of such bodies as per the rules of applicable for them, so and so. And the draft scheme in its current form has the potential to impose heavy long and term financial costs on the union government and rejected the concurrence. That is the first prayer. And the second prayer, very curiously, written in the nature of mandamus, directing the respondent authorities, more particular respondent 1, 2, 3, to accord approval or concurrence to the notification dated so and so issued by the administration, promulgated under the so and so, enable Andaman so and so to implement the said scheme. So mandamus is sought to bring in a scheme and accord approval as against the central government, which was initially forwarded by the administration. Now, this prayer has been considered by the learned single judge on presupposition in para number 5 of the finding of the learned single judge. Para? Where is it? No, yes, where is it? Yes, the fundamental right. Let's written it. Yes.
Yes,
Yeah.
para 354. Page 354. We have got it. Para 5 of the journal.
Yes, 5, that is that starts with the discussion. Then he proceeds further on the ground that there is a bounden duty on the central government to accede to the request and to grant the relief on the ground that mandamus even can be issued to frame the policy or the rules.
No, we are probably on different paragraphs. This is paragraph 5 of the single bench, single judge's judgment.
Yes, single judge judgment that starts with the discussion. Learned advocate appearing for the petitioner submits.
Right, right.
Yes, that's a discussion. Then finally he issues a direction in
Yeah.
para 41.
Yes, yes.
In of the discussion above, the objection of the Department of Personal Training cannot be accepted. Such a department is directed to accord approval of the scheme 23 as notified on so and so, so and so. Issues a mandamus to accord approval on the presupposition that a mandamus can even be issued to accord approval to frame a scheme or to frame the rules to that effect. Now, insofar as the administration of Andaman is concerned, it is governed by the constitutional provision, Article 239 and 240.
Constitution. Constitution.
This is mandamus. Okay. Just one second.
Abhi unna kitin sir. Yes, Mr. Advocate.
Yeah, please. I'm sorry. Kindly turn to page number 230, Article 239.
Yes, we are there.
Yes, I'm sorry. I'm good. Administration of Union Territories, save as otherwise provided by the Parliament by law. Every Union Territory shall be administered by the President, acting to such extent as he thinks fit, through an administrator to be appointed by him with such a designation as he may specify.
Right.
Then, notwithstanding anything contained in the part 6, the President may appoint the governor or the so and so. That may not be much relevant for this purpose. So, every Union Territory would be administered directly by the central government through an administrator appointed and subject to the law to be made to that effect.
Yes.
Now, 240 is the next provision, Article 240.
Yes.
Power of President to make regulations for certain Union Territories. The President may make regulations for the peace, progress, and good governance of the Union Territory. 1A, Andaman Nicobar, so and so, so and so.
Right.
So, all the entire administration of the Union Territories would be controlled by the central government in terms of Article 239 and Article 240. The President, on the aid and advice of the government ministry of the concerned ministry, or in terms of the allocation of business rules, the administration will have to be carried out.
Yes.
For this purpose, even the allocation of business of the government, that will be regulated again by the constitutional provision, that is by Article 166.
Right.
Article
Yes.
166, conduct of business of the government of a state. All executive action of the government of a state shall be expressed to be taken in the name of the governor. Orders is so and so, so and so. That is when there is an assembly. In other places where there is no assembly, then it will be directly under 239 and 240. It will be the executive power to be executed by the government of India in respect of union territories.
Right.
For that purpose, there will be a separate business rules would be framed, for which a separate allocation of business rules 1961 has been framed.
Yes.
I'm putting just a broad idea about it without getting into the individual aspect of the matter of the grievance which they have raised.
Yes.
So there is a rule called allocation of business rules 1961. I'm sorry, today I'm unable to place it before the sample court, but however,
if we get broad contours of it, then we can, yes.
Yes.
And you can refer to the particular provision if you want.
Please.
We'll look into it.
Please. So under which Ministry of Home Affairs has been appointed as the nodal ministry for legislative matters, finance, and budget and services of the for the UTs. So the administrative control
Yes. So therefore, Ministry of Home Affairs is the nodal ministry for legislative, finance, budget, service.
Yes.
Of UTs. Yes.
And the budget provisions in respect of UTs are under the administrative control of Ministry of Home Affairs.
Right.
So that is also in conformity with the Delegation of Financial Powers Rules 2024, and from time to time that has been framed.
Can you please repeat the name of that?
That's called Delegation of Financial Powers Rules 2024.
Right. Yes.
So these are the broad parameters under which the functioning of the UTs are regulated.
Okay.
For different purposes, there may be different nodal ministries, but when it comes to finance, budget allocation, and the administrative control of all UTs, whether it's Andaman or Lakshadweep or some other where there is a separate legislature,
yes,
it will be directly under the central government.
Right.
And that has to be governed and controlled and managed only through the allocation of business rules, which has been framed thereunder. Now, in the previous round of writ petition, the prayer sought was, now I am requesting the court to get into the prayer sought in the previous round of writ petition, which traveled to the Supreme Court.
Right. Yes. (76) is the order that Mr. Nataraj is referring to the prayers of the first writ petition.
First writ petition. I'm sorry. Yeah, that's exactly right.
No, you need not be sorry. We are sorry because you are not getting the pay. So give us some time because we are collating with the paper book actually. Writ petition is not a part here.
First paragraph should be 76.
Page 76. It has been quoted. No, stating what he wants to rely on those.
That's a WP 268 of 2018. That was the first writ petition.
In page 76 of our paper book, which is the judgment of that on that by the learned single judge, it's only quoted that the petitioners have sought direction upon the authorities to grant benefit of 1/30th of the minimum of the relevant pay scale plus dearness allowances in terms of the office memo dated June 7th, 1988 to all DRMs on and from date of their initial engagement. Only this much is quoted in the judgment.
Perfect. I'm not going beyond that. So that was the specific prayer sought in the first round of writ petition.
Right.
Now, in that context, The learned single judge granted certain relief. I have
Yes.
no quarrel about it.
Ha.
Then when it went up in appeal, the UT challenged in appeal.
Right.
There our appeal came to be dismissed.
Hmm.
In our appeal, now kindly see the previous direction which has been issued or the observation which has been made. In the previous writ appeal, which was filed by us.
Yes, right.
The first writ petition was filed by
boomerang.
yes, by the private parties.
Yes.
That came to be allowed. And at the most, what would be the scope of the appeal would be either to confirm or dismiss.
No, but Mr. Nataraj, we cannot totally overlook the scope of Order 14 Rule 33 principles.
That's right. I'm coming to that. Absolutely. I just I'm coming to that. I'm coming to that.
Yes.
I understood what is my difficulty also. I understand it, but nevertheless,
your difficulty is the most insurmountable, if you may say so, because you have to change stands now. Anyway, we understand and appreciate as
it's sometimes a legal stand. When it comes, we take that there will be no estoppel. That is the only thing.
Right.
So that was the single judge writ petition filed by some private party or the present petitioner, which came to be allowed for grant of a particular relief.
Right.
In our appeal, that was appeal filed by Union Territory. So at the most, what could be the relief? Either to dismiss or allow.
All right. Yes. For the time being, yes.
Yes. Now, in such proceedings, the division makes some observation in internal page number 3 of that division.
Nataraj, we cannot reopen that issue. No, that is merged now. Now, just you have to forget that. Whatever may be the pain and the injury.
Yes.
You have to forget that now.
The law is.
We understand what you're saying, Mr. Nataraj. We perfectly understand.
Yes.
Because these directions were passed might have been beyond the scope of the appeal.
Yes.
Right.
In such a situation, the effect would be, as you are well aware, even in 1954, page number 340, the constitutional bench way back in 1954. An observation, there are two propositions. Number one, the observation dehors the prayer or the relief. That may not be the ratio of the judgment, number one.
All right.
At the most, that has to be taken as either arbiter.
Yes.
Without taking as a binding precedent, which constitutes some kind of right on somebody.
We'll come to that immediately after we finish. Yes.
Yeah. The second part of it.
Yes.
Such a relief that cannot be construed as a right which can be conferred upon somebody to enforce something beyond in the second round of litigation as a foundational fact.
Now, Mr. Nataraj, with regard to the first proposition which you are advancing, we understand that regarding Article 141, ratio decidendi, those principles, these are not applicable as binding precedents in case of third parties, but you are a party there. And you cannot get out of the rigors of that. Even if it's obiter dictum, if there's a specific direction, please convince us that you being a party there specifically, you can get out of the rigors of that. This is not on the principle of precedents, but this is binding on you because you are a party there. It's on a higher footing.
Now, even in 1954 Supreme Court, page 340, the law laid down by the constitutional bench is that and which has been followed in Catena of decisions.
Yes, we agree with that. I mean, there cannot be any quarrel with that proposition.
Yes.
Even if you take it as obiter dictum. Now, does it not bind the parties to that, even if it's not a binding precedent on others under Article 141?
That's right. There are two propositions. One is, let us take it as an obiter. Number one, any such observation which does not constitute ratio of the judgment, that can be taken up as a ground in any even in collateral proceedings. That is a law laid down in 1954, 340.
Yes. Yes.
And
Yes.
number 3, there can be no estoppel against the statute. Therefore, I was relying upon Article 239 and 240 being the
Alright.
constitutional provisions.
Right. No, Mr. Natas, there cannot be any quarrel with the proposition that you are governed by the union.
Correct.
Broadly speaking. But
Yes.
that's a double-edged sword for you also, because you have framed the scheme.
Correct.
And if you are governed by the union, we are coming to the meat of the matter.
Right.
Because arguments have been advanced by both parties at length.
Right.
So we are coming to the meat of the matter. If you say that you are governed by the union,
Yeah.
and the AG, the Attorney General of India, the learned Attorney General, he, after high-level committee meetings at his residence in Delhi, that's the statement made. After that, he has come to this, he has suggested modifications, and you have framed that scheme and sent it. Under threat of contempt or otherwise, whatever, we are not concerned with that. Because maybe under threat of contempt, but
Yes.
you did that. And you have also written several times to the union ministry. So if you are an instrumentality of the union in a sense,
Correct.
then that should bind the union also. Union cannot feign ignorance to that.
Yes.
So isn't your argument counterproductive to your earlier stand in the wherever? I mean, this is issue estoppel also in a sense.
Yes. That's what I'm pointing out from 3 counts. Kindly appreciate from 3 counts. It's a pure, I'm putting only a legal issue before the Honorable Court.
Right.
Number 1, the nature of the direction or observation made in the previous round of writ petition. Let us take it is between the parties.
Yes.
That is not the
Ratio
of the judgment. It is
Right.
only an arbiter. Number 1.
Yes.
Number 2, such a direction or observation, even it is construed to be found place in the particular judgment, that can be set up even in collateral proceedings as that being without jurisdiction.
Very well. Yes.
Number 3, there can be no estoppel even against the statute, especially in the instant case. This is a constitutional provision, not even the statute.
All right.
These are
So
the 3.
estoppel, you mean these 2 articles, say 49.
Yes,
Yes.
239
Right.
to 240.
Right.
Now, if you take the previous direction of the division bench, kindly have a look at it. If I'm not troubling the Honorable Court and taking more time of this one.
No.
Please.
Yes. Yes, please. No. We have it before us, Mr.
Please. Kindly go to internal page number 3.
Yes.
In fact, it is submitted by the administration and affirmed by the learned counsel for the writ petitioner that the administration has already commenced implementation of the memorandum dated 7th, 1918. That's a fact. It is therefore ordered that circular and process of framing of a scheme for regularization and every other benefit under the aforesaid 88 circular duly addressed would mandatorily and positively be brought into force within next 3 months. So in the passing of the particular judgment, while granting the relief of 1/30th of the pay, this particular observation is made in the context of some statement made.
This may be beyond order for 2033 also, because this is not one of the orders which could or ought to have been passed in the suit.
Absolute.
Get your point.
Yeah. Now, what went to the Supreme Court in the matter of implementation of that financial benefit? The contempt was filed. It is not the contempt arising out of this particular order as such.
All right.
Initially, when it came before the learned single contempt court of this High Court, certain nasty observations are made. Anyway, I am not getting into that. However, what traversed to the Supreme Court was in the context of the implementation of the relief or 130th pay commission, 130th of the relief. In that context, kindly take the order passed in civil appeal number 5014 of 23, dated August 14, 23.
And it starts from 100.
Before you go ahead with this, Mr. Nataraj, we'll just put you on caveat because something has caught up. Now, the paragraph 2 of the Honorable Supreme Court judgment in the previous round, that content matter, the judgment you were referring to, that says that takes into account that the above directions were modified by the revision bench. So there was a merger. So on that basis, the Honorable Supreme Court proceeded on that premise that that merged order was under control.
Yes, sir. No issue.
All. So you can please.
Now kindly go to that order, para 10.
Yes, para 10.
In para 9, they refer to the additional affidavit filed before the Supreme Court. Then para 10, with regard to the regularization scheme, it has been stated as follows.
Right.
It is submitted that the administration is in the process of formulating a scheme for regularization of the DRMs in accordance with the so-and-so. As such scheme is required to be compliance with the direction stipulation laid by the Honorable Supreme Court and the Honorable High Court, the contours of the scheme presently being worked out. It was pointed out in the context of the contempt for implementation of that 130th of the benefit to be given. Then kindly come down to para 13. It is stated that in the present scenario, the total number of daily so-and-so that is on facts. Now kindly turn to the next page, para 20. It is submitted that all the above steps to regularize are subject to concurrence and ratification by the DOPT. Kindly mark it.
Yes, that has been argued in clear terms, and we find that. Yes, there's no doubt on that.
Yes, that was the categoric affidavit filed before the Honorable Supreme Court in the context of the contempt emanating from the relief initially which was granted in the context of the prayer sought in the writ petition.
Yes.
So at no point of time or with no stretch of imagination, it can be construed as the direction or any commitment which has been made before the Supreme Court that there will be a scheme which will be accorded approval by the union in terms of the proposal set by the administration. Now, two things. In terms of Article 213 and 240, every proposal will be initiated by the concerned administration of the wing, and thereafter it goes to the central government. Central government has the ample power, has three options, like under Article 200, where the governor has the option. They have three options. Number one, it can accord approval with or without modification. Number one, it can reject the proposal. Number two, number three, it can return the proposal for proper consideration or with the further clarification.
Yes.
In the instant case,
but there the similarity with the governor ends probably.
Yes,
further.
Somewhat similar to the Article 200 power of this one.
Up to this, yes. But if it's returned again, then
that's right.
It's a different domain.
That's right. That's under Article 200, because once it is returned, what is to be taken?
200, that's under, anyway, that's debatable now.
Yes, debatable. Anyway, we will not go into that. But the options available before the central government are threefold, basically.
Yes, true.
To accord approval with or without any modification, number one.
Yes, yes.
Number two, to accord. Number two, to return with the certain. Now, in the present case, only the proposal has reached the central government. Then after the proposal, the central government will have to take a call as being the complete administration is controlled by the central government under Article
239 and 40.
Yes, 340. In such a situation, the mandamus is sought now. Yes, the decision taken by the government, that is wrong. And the prayer is sought, yes, you grant accord approval. I am afraid such a mandamus would at all be issued to frame a policy at all or to frame any rules.
So that would be a convergence or transgression by the judiciary to the executive's domain.
Yes.
All right.
At the most, with the due respect, in the matter of separation of powers, as we regularly notice,
Yes,
court can say, yes, government can look into the matter. Yes.
Consider this.
Yes, consider this, having regard to this work, it's for the government to consider whether. Now, when it comes to the administration, this is not the only sole union territory. Now, let us take, when the formulation of scheme is concerned, there are multiple union territories, and one union territory can send the proposal in respect of one. There are multiple union territories.
Basic economics, Mr.
One is economic.
Allocation of funds, yes.
Yes, number one is economic. The number two, the scenario specifically emerging in each union territory. Let us take a Ladakh. The scenario would be different. We can't go into the regularization of certain issues, especially having regard to the border area. You go to Lakshadweep, the scenario, there is a all particular entire community is 100%, it is a notified as a scheduled caste. So the scenario in each union territory would be different.
Yes.
So you can't, in isolation, you can't seek a prayer to grant a uniform policy or frame a particular policy pan-India, dehorse other union territories.
All right.
In such a situation, in the present scenario, ultimately, after an elaborate argument of the entire issues on facts of individual case, one may have good case to be regularized individually in a particular case. A particular person comes before the court. Look, I'm here for about 15 years, 20 years. My case has to be considered on individual case. In appropriate case, I'm not saying that such a relief cannot be granted at all. The consideration would be different. Even when the matter reaches to the Supreme Court, on facts of the case, court may say that, yes, we do not want to interfere. Yes, let him be regularized, having regard to the particular facts and circumstances of the case. Here, the direction is to come out with a particular policy and to accord, which presupposes the administration is, the union is subordinate to administration.
All right. All right.
In such a situation, I'm not getting into the individual issue or the facts of a particular individual. So the matter requires a detailed consideration having regard to the ramification, not only the financial, but the pan-India ramification, and keeping in mind the constitutional provision.
All right.
The matter requires some kind of consideration by Honorable Court. So with this, I would like to conclude my submission without getting into the facts of the case, as we have already framed some policy. I'm grateful for kind opportunity, and as I reiterate my first stand. To
No, very well, Mr. Thank you so much.
I'm grateful, please.
If Mr. Nataraj has completed, Mr. Kumar, do you want to add anything to this? Because we did not take your reply to this. And then we'll go to Mr. Sanjay for a comprehensive result. Use the microphone.
Leonard Fredel said that it is only an arbiter. My lord, two things are there. If there are four issues, one issue in respect of a party is decided at any initial stage, that is inter-party binding. If either of the issue. Now here entire proceeding was culminated, and my lord, it's my respectful submission, it was not an obiter. It was a direction of the court. Secondly, my lord, my learned friend has said the contempt was pertaining to only the compliance of the single judge order so far as the 1 by 30th. No, my lord, can we see the first order of the contempt at paragraph number 6, my lord, page 91. Because what happened, my lord, under the garb of compliance, my lord, they want to take an undertaking that their service will not be regularized. Therefrom, we filed a contempt application. Para 6, the court says, this court find that the purported affidavit of compliance says nothing about framing of any scheme or the illegal and continuous distribution of what to be done. So, my lord, it was a subject matter. So, the Supreme Court has considered it. So, it cannot be. My lord, my learned friend has made a gentle submission, my lord, so far we have to consider the facts and circumstances of this case. And Article 239, my lord, my learned friend will not dispute that it is a constitutional function which has been discharged by the administration. It is not only an executive, it's a constitutional function under Article 239. So this is my submission.
Yes. Let us go back to Mr. Sanjay. Yes, Mr. Sanjay. For a comprehensive rejoinder.
Lordships. My lord, sir.
Not very comprehensive, Mr. Sanjay, in a nutshell.
I will not be repeating my submissions, my lord,
No,
which
yeah,
I have made, because I understand that my lords have taken note of my submissions
Yes,
in my
yes.
earlier round, my lords. Now, my lords, what I have understood from the arguments of my learned friend, my lords, that is, my lord, basically I'll just summarize his submission. What I have understood, my lord, that first, that Uma Devi has been diluted by the recent judgment of the Supreme Court.
Yes.
That is of the argument of my learned friend. Number two, learned Attorney General was the part of the
Exercise.
framing of the scheme, my lord.
Yes.
And he, being a constitutional authority and also a spokesperson for a union, therefore it is unfair for the union to say that they will not accept. But number three, my lords, that since AG was a party in the framing of the scheme, therefore it will be implicit that Ministry of Home Affairs knew about the direction of the court, my lord.
Yes, Mr. Sanjay, we have added something to that in favor of the them, which we expect you to answer. That we find it reflected in the Andaman administration communication that this not only that the learned Attorney General of India advised, but it was preceded by several quote unquote high level committee meetings held in his residence in Delhi, presupposing that there was some involvement of the union also in a sense. So he was the Attorney General, no doubt about his being the learned Attorney General, and high level committee. We are stressing on that. So therefore, whether the union can feign ignorance, if you may use the expression, of that entire exercise or being a part of it. So you add that to your rejoinder also.
Lordship. Now, my lords.
Yes.
Then, my lords, another point was that Andaman administration posts are created by MHA. Just posts are created by MHA, and therefore it will be deemed to be within the knowledge of the Government of India. And then, my lords, the state is a model employer, and therefore it is expected from the state to act fairly and to regularize all of them. And then, my lords, another was that it is not only an executive decision, but it was consequence of the judicial order. So precisely these are the arguments which I have understood from my learned friend's argument. Now, my lord, I will answer the query of my lords as well as the argument about the Attorney General. But before that, my lords,
let me respond to the submission of my learned friend that the judgment of Uma Devi has been diluted in the recent judgment by the Supreme Court.
Yes.
Milords, I'm putting a question to myself, Milords. Milords, Uma Devi judgment. Now, Milords, Uma Devi judgment, if your lordship will take my compilation, is a constitution bench judgment. If your lordship may kind have pleasure to see, Milords.
We'll just go, look into your compilation. Give us
Lordships.
Compilation is Yes. Sorry.
Lordships.
Yes, Uma Devi was constitutional bench, no doubt about it.
No doubt about it, Milords.
No.
Now, Milords, I am putting a question to myself whether any judgment lesser than 5 judges can have any effect of diluting a constitution bench judgment. Milord, my lord must be aware, Milord, that recently Sabrimala is under hearing, Milord. The judgment of Sabrimala case, and it is being reconsidered by 9 judges bench.
Yes.
Milord, there was no need, if at all, what my learned friend has argued, that it has been diluted or it can be changed by any judge of lesser number, then there is no need to constitute a larger bench. Then, my lords, again, I am reminded of that India cement judgment, my lord. Now, my lords, earlier the judgment has recently been, my lord, tinkered and changed by the 9 judges bench, my lord. And the entire view which was taken earlier, now complete a divergent view has been taken now. And that has been done away with, my lords.
So therefore, a lesser bench, a smaller size bench could not have diluted or tinkered with or whatever.
Yes, such argument cannot sustain because it will be against the judicial discipline and hierarchy, my lord. Then tomorrow, my lord, a single judge sitting can, my lord, override your lordship judgment or dilute your lordship judgment, division sitting in division bench. No, my lord, with respect, it is not permissible. And then, my lord, in that context, I am reminded, and I may, my lord, invite my lord's attention to para 54 of the judgment in Uma Devi case, which says, my lord, at page, my lord, starts from page 42, my lords. Kindly have pleasure to see me.
42, yes.
Lordships. Paragraph 54, my lords. If lordship could get, my lord.
Yes, we have got it.
Lordships. Now, my lord, their lordships of constitution bench, my lord, have clarified. It is not even majority or minority. Unanimously clarified. It is also clarified that those decisions which run counter to the principles settled in this decision, or in which directions running counter to what we have held herein, will stand denuded to their status as precedents. Now, my lord, some judgment which had been delivered prior to Uma Devi, if their lordships have clarified that they will have no precedential value, can, after the Uma Devi judgment, without overruling it or modifying it, can a different view be taken on principles? Of course, my lord. So far as the fact of individual cases are concerned, your lordship, the courts may take a different view in a given set of facts, my lord, in a given circumstances, in a given situation. But whether on principle it can be diluted by a judgment of a lesser number of honorable judges of any court, including Supreme Court, my lord. Lord, my most humble submission for your lordship's kind consideration is that no, it is not permissible. Then, my lords, one more paragraph. My lord, that is, my lord, judgment starts from page 41. My lord, paragraph 41. Yeah, judgment. नहीं, यही वाला. Oh, ये दूसरा है. Oh, I'm sorry. My lord, this is another judgment In our compilation, which starts from page 45,
Yes.
running page 65, my lords. This is Indian drugs and pharmaceuticals versus the workman. In para 41, could your lordship get it?
Yes, we got it.
Page 65 of the compilation, my lord.
Yes, para 40.
Lordship, it says, no doubt, my lord, this judgment is of 2007, my lords. 2007 1 SCC 408. Now, my lord, it was also a division bench judgment. Now, this says, no doubt in some decisions, the Supreme Court has directed regularization of temporary or ad hoc employees. But it is well settled that a mere direction of the Supreme Court without laying down any principle of law is not a precedent. It is only where Supreme Court lays down a principle of law that it will amount to a precedent. Often the Supreme Court issues directions without laying down any principle of law, in which case it is not a precedent. For instance, the Supreme Court often directs appointment of someone or regularization of a temporary employee on payment of salary, etc., without laying down any principle of law. This is often done on humanitarian consideration, but this will not operate as a precedent or binding precedent on the High Court. For instance, if the Supreme Court directs regularization of service of an employee who had put in 3 years of service, this does not mean that all employees who had put in 3 years of service must be regularized. Hence, such a direction is not a precedent. Then, my lord, in Municipal Committee Amritsar versus Hazara Singh, the Supreme Court observed that only a statement of law in a decision is binding. In the state of Punjab versus Baldev Singh, this court observed that everything in a decision is.
I need not read the entire thing. I have read it, and it's well settled. Everything cannot be ratio decision there, and also Article 142 orders and not.
So now, my lords, coming to the judgment which has been cited by only 2-3 judgments, I will just make a distinction, my lords.
Yes.
Now, if your lordship will take those judgments, my lord. Now, my lord, the one judgment is of Dharam Singh and others versus state of UP.
Dharam Singh, yes.
Now, kindly see, my lord. This is a judgment by 2 honorable judges.
Yes.
Honorable Justice Vikram Nath and Honorable Justice Sandeep Mehta, my lords.
Yes.
Now, my lord, kindly see, my lord, it starts with the word, when public institution depends day after day on the same hand to perform permanent tasks, equity demands that those tasks are placed on sanction post and those workers are treated with fairness and dignity. So it is not a judgment based on law, but it is based on equity. Then, my lord, kindly see this paragraph 6 of this same judgment, my lords. Paragraph 6.
Paragraph 6, yes.
The question before us is whether High Court erred in failing to adjudicate the appellant's principal challenge to the state's refusal to sanction post. But here, the writ was filed seeking a mandamus upon the state to sanction post. So, there is a distinction on facts here that this is an order by the Supreme Court, and that order will be treated to be under Article 142 of the Constitution, not under a law laid down under Article 141 of the Constitution, my lords.
All right.
So, therefore, this judgment is completely distinguishable on fact, my lord, on equity considerations. Now, my lords, there is another one paragraph more, my lords. Having heard learned counsel for the parties and perused the record, we are unable to endorse the approach adopted by the High Court. The original writ petition before the High Court expressly states refusal dated 11/11/99 to sanction post for the commission and sought a mandamus for creation of post with consequential consideration for the appellants. Single judge and division bench treated the matter as a bare plea of regularization, answered it only on touchstone of absence of rules and vacancies, and rested principally on Uma Devi. Doing so, the court below failed to adjudicate the principal challenge of the state's refusal and legality of its reasons. So, my lords, this judgment was not on regularization, much less on regularization on the touchstone of Article 14 and 16. It was for seeking a mandamus to sanction post. So, therefore, so far this judgment does not come in aid of my friend, my lord, in reasoning out from the principle of law laid down in Uma Devi's case, my lord, by the Constitution bench.
Okay.
Now, my lords, another judgment. Another one more judgment, my lords. My learned friend has relied on another judgment, that is Bholanath versus State of Jharkhand, my lord.
Yes, Bholana.
Again by the same division bench, my lord, of the Honorable Supreme Court.
Yes, yes.
Now, my lord, here is a case where the employees were directed to be regularized, and it was held, my lord, that they have been recruited on after taking into account their qualification, their eligibility, and by advertisement. It's not that ad hoc, casual, or employees or who were just taken for some time to work and thereafter their extension was granted by them and they continued and thereafter it is. So this is also factually completely different. It will never amount to be, my lord, diluting the judgment of Uma Devi, my lord, which the division bench could not have done so. Now, my lords, then your lordship will consider that similarly, my lord, all these judgments cited by my learned friend, my lords, the recent judgment, he said recent judgments he is citing, my lords, and that they have diluted the judgment of Uma Devi, my lord. No, with profound respect to my learned friend, my lords, they have not diluted that principle. Otherwise, my lord, till date, Uma Devi has not been referred to any further larger bench, my lord. If the jurisprudence of service or employment in the manner in which it is being done, if there would have been any divergent view of the Supreme Court, my lord, it happens, my lord, time to time.
Yes.
Constitution is, my lord, a living document, and time to time, as per the need of hour, the view of the, my lord, long-standing and settled view gets unsettled after 30 years or 20 years, my lord, with change of time. But, my lord, Uma Devi has been tested with times, my lord, and till now it has never been referred to larger bench. We have seen, my lord, every day number of judgments are referred to larger bench, but Uma Devi has not.
Yes.
Because it has taken into consideration constitution. Because, my lord, merely on equity, the government cannot function. Because, my lord, otherwise the another set of people who are waiting, with whom, my lord, if, my lord, suppose, my lord, one IAS officer, he has got 5 persons of his village, and in the name of work, he brings them to work. He goes, but those people continue to work. And thereafter, they are entered into service, my lord. Now, my lord, my lords have completely deprecated it, that no, that because this is completely against the constitutional scheme, that the people should get into service, not through backdoor, but through regular process of recruitment, sanctioned post. So all those jurisprudence have been taken into consideration in Uma Devi, and therefore, and few subsequent judgments, my lord. Therefore, the Supreme Court has not yet referred it to any larger bench. And my lord, one more judgment they have cited of
Yes.
Shivnarayan is also in the given facts of the case, my lord. So, my lord, they are dealing with certain individual employee with respect to his recruitment, how he came into service and all that, or a group of 5, 10, 60 employees. Now, here is a case where persons has been sought to be regularized, directed to be regularized from 2006 to 2023, my lord.
Yes.
7,520, my lord, by one stroke of pen. My lord, rightly said, my lord, in some judgments, that by the load, the organization itself crumbled down. My lord, whether there is any need of such employees or not, whether they will be of any work or not, it can't be done, my lord, with due respect, my lord. Now, my lords, coming to the argument with respect to a learned attorney general, my lords.
Yes.
Now, my lord, let me clarify. My lords have by now, my lord is fully well versed with respect to the facts of this case and the circumstances in which the contempt proceeding reached to the Honorable Supreme Court, wherein a division bench had directed, my lord, in contempt proceeding to suspend the Chief Secretary of the Union Territory. and also directed the Lieutenant General to remain present. Now, my lords, in
Yeah.
that background, when the matter went to Supreme Court,
50,000.
lordships. Now, my lord, in that background, my lord,
Yes.
my lord, the administration requested the learned Attorney General to protect them in the Supreme Court, which he was doing it. And in that connection, my lords, the administration was helped and advised that in the light of the judgment, you formulate a scheme. So, my lord, this scheme is nothing but a proposal of the Union Territory Administration, my lords. Now, my lords, if I invite my lord's attention to the very scheme, my lords, if your lordship can come to the scheme for a moment, if kindly come to my lord, kindly if your lordship would take up the memo of appeal, my lord, that volume 1, if it is with your lordships, my lord. I'm sorry to bother your lordship because I don't have the paper
What are you
book, my
trying to place? What are you trying to place, Mr.
my lord. I just want to show 1-2 paragraphs in the scheme itself, my lord. My lord, in the paper book, my lord, I don't know the page number, but in the memo of appeal, my lord,
180.
We have got it, yes.
my lordship could get it, my lords.
Yes.
Now, my lords, kindly come to the internal page 10 of the scheme, my lords. Yeah, sorry, internal page 2, my lords.
Yes, internal page 2.
My lords. Now, my lords, in the scheme itself, it is mentioned. My lords, kindly come to internal page 2 first. Second paragraph. And whereas, based upon the above judgment of the Honorable Apex Court, internal page 2, your lordship could get it, my lords.
Yes, we have got it. You're reading that.
Now, my lords, this administration, why it was done, it is mentioned here that whereas, based upon the above judgment of the Honorable Apex Court and in pursuance to the DOPT, so and so OM of 11/12/2006, a committee was constituted to consider and recommend framing a common policy and scheme for engagement and regularization of DRMs in Andaman Nicobar under the chairmanship of the then Chief Secretary Andaman and Administration for engagement and regularization of DRMs working in various departments under this Union Territory Administration. Based on recommendation of the committee, while minutes of the meeting dated 21/11/14, with the approval of the competent authority, the services of 121 DRMs engaged under Environment and Forest Department were regularized on ad hoc basis, white number dated 21/5/15, and subsequently the ad hoc services of 121 employees were regularized, white order dated 12/7/21. Now, my lord, up till then, my lord, there was no need to take concurrence from the government of India. Now, my lord, because this is in this scheme, now kindly come to the next page, my lord, that is internal page 3, top first paragraph, my lord. Now, my lord, kindly see, my lord. Whereas being aggrieved, the Andaman Nicobar administration filed a civil appeal on 4/8/23 before the Honorable Supreme Court of India, wherein it was represented by learned Attorney General. So, my lord, it is not that the Attorney General is acting as a spokesman of Government of India or acting as an Attorney General. Now, my lord, learned Attorney General is here defending the Andaman and Nicobar administration in his capacity as a senior advocate. He has been defended. My lord, the name of Attorney General cannot be removed, my lord. He is an Attorney General. But then he acts in different capacities, my lord. My lord, Attorney General also appear for PSUs, my lord, in number of cases. He appears in arbitration. But there his capacity is not as Attorney General, but as a senior advocate and law officer of a government. Whereas Attorney General is also a law officer of the government. So he acts as a law officer of the government. So, my lord, here, being aggrieved, Andaman Nicobar filed a civil appeal before the Honorable Court, wherein it was represented. So, Andaman Nicobar administration was represented by learned Attorney General for India. And during the proceedings before the Honorable Apex Court, as advised by learned Attorney General of India, the administration had prepared salient features of a scheme
for regularization of casual Mazdoor, daily rated Mazdoors and filed an additional affidavit before the apex court, stating thereby that the
We get your point, Mr. Sanjay, that he was very for the administration.
two, three lines are more, my lord, important. Kindly permit me to place, my lord.
Yes.
Stating thereby that administration is in the process of formulating a scheme for regularization of DRM in accords with so and so 2020. Further, now, my lord, kindly see.
Yes.
In the proposal itself, further, all these steps to regularize casual laborers DRM are subject to the concurrence and ratification by the Department of Personnel and Training, Government of India.
That is there.
So it was, this scheme was only a proposal, my lords, nothing more than a proposal. And AG advice was taken in framing of the scheme, in formulation of the scheme, so that there may not be any glaring or gross illegality committed, which according to the administration was earlier found under fault by the court, my lord. Therefore, for that purpose, limited purpose, it was being done. But then it is all subject to concurrence and approval by the Government of India, DOPD.
Very, very.
This condition
Now, my lord,
must be required.
if AG would have been representing the union, that such condition would not have been required, my lord.
Right.
Therefore, learned AG
It would not be
had,
subject to ratification.
your lordship, then, my lord, had AG been there, my lord,
Yes.
representing the Government of India, my lord,
Yes,
then
yes.
there was no
Okay,
need
good.
for, because the view of the AG, and my lord, one more thing, my lord, kindly, my lord, opinion of AG is only in realm of opinion. It is not a decision of the government, my lord. The decision of the government, my lord, is finally taken by the Government of India, by the competent authority, my lords.
Definitely.
Even opinion of the AG is not binding on the government,
It is advisory.
lordships. And one more thing, my lords, that your lordships, under Article 143, presidential reference is made. Now, my lord, it is made to the court, not to the AG, my lord. AG being the topmost law officer and advisor to the government, still the Honorable President seeks advice even under advisory by the Supreme Court, not by the learned AG. So, my lord, that is binding on the government. But then, my lord, the advice of the AG is, even when made to the government, is not binding. Now, in the present case, the advice of learned AG was not to the Government of India, nor he represented Government of India. He was, in the given fact of the case, merely representing the Andaman and Nicobar administration. And his advice was to formulate the policy was to the administration and not the government.
All.
So this is my answer to the second query, my lords, and also to the query of my lords, my lord, that
Yes.
he is a spokesman of the Government of India when he is speaking for Government of India, not when he is speaking for any third party.
All.
Here, Andaman Nicobar cannot be said to be Government of India, but they themselves has mentioned that they will seek approval of the scheme, which is only a proposal which has to be approved by the Government of India.
So he was wearing a different hat in a sense.
Yes.
So we cannot
Completely.
confuse his constitutional authority position with a position as senior counsel.
Grateful, my lord. This is what I want to, my lord,
Understood.
impress upon my lords, my lords. My
Understood.
most humble effort is to persuade my lord on this issue, that it is in a different
Thank you.
capacity that learned AG.
Yes.
Now, my lords, so far as another meeting, etc., in Delhi, my lord, does not, my lord, because it was convenient for him to hold a meeting, the
It does
officers.
not lead us anywhere. Basically, there is no
No.
clear indication that it was in the government was involved.
Your lordships.
All right.
And my lord, so far as the model employer, my lord, question. Now, my lord, model employer is, of course, the government is model employer. My most humble submission is, my lord, that model employer has to balance and has to maintain the equilibrium. That Article 14 and 16 is maintained. All those who are meritorious people, they first get into employment. Not merely that somebody has come and joined through some of his known person in the service and has worked for some time, then the right of those meritorious to be considered and get employment should be overridden by those who are working, rather who got benefit of undue favor by someone.
in the name of equity. Now, my lord, equity will be for both of them, my lord, and it must be balanced. Therefore, merely because some people had come in the organization and worked for some time, that does not mean that they should be given priority over those who can be considered on merit. And irrespective of their eligibility, their competence, everything cannot be given a go-by, my lord. And therefore, Uma Devi has considered in detail every aspect of the matter and come to the judgment.
Right.
And, my lords, so far this decision of the government, my lords have shown, and I have shown to my lords that the Honorable Supreme Court in the last order had said that Government of India was not a party. So if
Yes.
now a de novo exercise on the issue of, my lord have seen the first round litigation was from completely on different thing. And the Government of India has also complied when the court, it came from the court to make the payment, 300 crores was paid by the Government of India. But, my lord, here is a case where it is a consensus decision, my lord, in one stroke of pen, without considering everything, 7,520 person cannot be taken into employment, my lord. It will completely destroy the budget, my lord. Completely create a disbalance of the budget. So, my lord, individual cases, if they come to the appropriate court by showing their right, that can be considered. Not through this organization which has come and every and anybody has been included in that, seeking employment on a regular basis and thereby causing huge, my lord, leakage to the public exchequer, my lord. My lord will also consider the public exchequer, my lord. Otherwise, where from the money will come? My lord, the money will come from the taxes of we,
Yes.
my learned friend, your lordships, and every citizen of the country, my lord, every taxpayer of the country. So,
Right.
therefore, if there has been certain illegality, there cannot be allowed to be perpetuated. So the people of the country cannot be made to suffer in the name of few private persons for their employment, my lords. My lord, these are my submissions precisely, my lords. Now, if your lordship so pleases, we will also file our short notes, my lord, for your lordship's kind consideration. Subject to, if at all your lordship so needs, my lord. Otherwise, my lord, we have made our submissions orally. But then,
Because we asked the respondent number 1 to file their written notes. So a brief bullet point 1 will do, because we have taken extensive notes of your arguments.
lordship,
But something should keep something on record, so bullet points at least.
as your lordship please. Within 2 days, my lord, we will furnish it.
Mr. Sanjay, it has to be by tomorrow. Otherwise, we won't. We'll be leaving the
All
island.
right, my lord. By tomorrow, my lord, because my lord,
Thank you so
I
much.
remember
Thank
my
you.
lord said that before leaving the island, my lord will deliver the
We
judgment.
want to pass a judgment on this. If you carry anything to the mainland,
No,
there will
my
be
lord.
more pressure. You know our situations.
Yes, my lord, I am so conscious of that, my lord, no difficulty. I
Thank
am
you.
deeply grateful, my lord, for such a patient hearing. It was very pleasure for me, my lord. I wanted to come down there, my lord, physically.
That would be more
But
pleasant.
because of the compelling reasons, my lord, I could not leave, my lord.
No difficulty.
I'm
Thank
deeply
you so much,
grateful.
Mr.
I'm
Sanjay.
deeply
And the Andaman administration will also request a brief written notes.
Lordship, I'm deeply grateful, deeply grateful.
Just reply.
No reply to it.
Only one thing.
No reply to it.
Only the judgment with regard to judgment.
No further reply. We form our own opinions. This will never end otherwise.
No. Because
You can say to yourselves, we will overhear you. Written notes of oral arguments are concluded. Sir, the written notes of arguments filed on behalf of the respondent number 1 be kept on record. Sir, next para. Learned Senior Counsel appearing for the Union of India and the Andaman and Nicobar Islands are requested to file their respective brief written notes of arguments, if any, by tomorrow. The matter shall be listed tomorrow under the heading to be mentioned for such limited purpose. Thank you.
My lord, so may I seek one indulgence, my lord?
Yes.
Your lordship have mentioned Senior Counsel for Union of India. Instead, lordship may record additional Solicitor General for.
Oh, I'm extremely sorry. I'm extremely sorry.
Nothing to be sorry, lord. I'm sorry.
Learned Additional Solicitor General of India appearing for the Union of India.
SD Sanjay, my lords.
What is the designation of Mr. Natarajan?
He's also
He's also SJ.
both of us.
Sir, Again, we'll use SGI for Andaman administration, and the same thing will happen in the next round of litigation. Beware of that. You have no problem with that.
No,
SGI,
no difficulty.
SGI for Mr. SD Sanjay, appealing for the Union of India, and learned ASGI, Mr. Natarajan, appealing for the Andaman and Nicobar administration. The rest of this. Thank you so
Deeply
much.
great. Deeply great.
So what else to be mentioned for those notices?
Lordships. Deeply great.
Place this 139 at the 17th October 23 or the some other letter of the 17th October, some other page. There's a 17th, there's only 139, huh?
So two letters are
There are two letters.
yes. 30th August is 139 perhaps, 30th August, and thereafter 17th October.
17th October is 130.
Yes.
Saying that regarding the
Yes,
conference and the Raj.
Yes. Yes.
His notes and my notes together. Very good. First, you keep that somewhere else.
I will.
1 second. You have arrived with a bang. Mr. Stephen, please get over it. If this where it was,
Which one?
this was there, kept there.
No, it is here. It
No,
was
no, it was not here. You can actually not know.
it
This-
has-
Oh, but this was over there because maybe.
No, it's here.
Achha. But it's not functioning now anyway. Yes, Mr. Call on the next one. 8, yes.
Fresh item by that John Mr. Classes request. This is that case, my lord, where my lord, the delinquent officer, my lord, proceedings were carried out against him and he was dismissed. And the learned cat, my lord, has held that there was misconduct and the proceedings was in accordance with law. However, at the very end, my lord, of the judgment, the learned tribunal has held that
My lord,
the order was passed by the chief secretary and not by the secretary personnel who was the
Appointing.
no, the appointing authority is admittedly the chief secretary.
Oh,
But the tribunal has held that because as per the gazette notification, the disciplinary authority was the secretary personnel. So therefore, the order passed by the chief secretary is bad. But my lord, this is contrary to law, my lord, with respectful submission. Firstly, my lord, Article 311 of the Constitution. We have, my lord, we have also annexed the article state petition. Kindly have page 505.
Mr. Chakrathi, we won't be able to conclude in 2 minutes.
my lord, item number 8, my lord, kindly fix tomorrow, my lord.
So, my lord, only request is, my lord, this is it's for admission, my lord. There is a direction at the of the order saying that he has to be reinstated. I have no difficulty, my lord.
You're seeking a limited stay.
My lord,
You're seeking an interim order.
because there is a direction to reinstate him. Only to that extent, my lord.
Achha, give us half a second. Stephen, tomorrow do you have any other top matters? No. Just check out. So the single bench is somewhere else. We'll keep it tomorrow only. One top matter we have already heard. On the top matters we have probably heard. This is also top matter.
Yes, my lord.
So this will retain its position. This becomes a actual top matter.
It is top.
Top.
My lord,
So,
before
take it
my
up.
lord rises,
We have
Before-
reasonable.
my lord, before my lord rises, my lord, may I be permitted, my lord, to mix
We can't see you.
number
What are you?
11?
Chintaman. I can't. Exactly.
Yes, now I can see you, Mr. Bennett. Thank you. Yes, Mr.
My lord,
Bennett.
the thing is, my lord, somehow pursuant to my lord's direction, I have prepared the affidavit in reply, and when junior is there, he will be filing. But the personal difficulties, my lord, this is such a matter, a detailed list of date and a comprehensive note would be
Which one?
required.
Which one?
Item number 11, my lord. And I am, my lord, practically, physically, my lord, unable.
11 will not call today. When it is called on tomorrow, then we'll consider, Mr. Banerjee.
Tomorrow, that is the difficulty. That's why I was submitting. Tomorrow, my lord, I have some other fixed matter in the
No,
principal.
keep somebody and ask for adjournment. We'll not take it out of turn and adjourn.
I see. I
Keep
see.
somebody or ask somebody to ask for time, Mr. Banerjee, no difficulty.
As my lord, do this.
ठीक है ना? ठीक है तो একটা তো বাজে না গ্রাম আছে প্রথমে
চলো, আজকে হবে না।